No, I don't know that there'll be questions or not. It just hasn't been reviewed yet.
Okay.
Okay, so we'll call it first. Will you remind me to call it first? All right, good. All right. So we're back on the record and I'm going to call a case that we called earlier and are in recess on. Thank you. I'm going to call case 25951 Hillcorp Energy.
Good afternoon, Mr. Hearing Officer, Division Adam Rankin with the Santa Fe Office of Holland and Hart, appearing on behalf of the applicant Hillcorp Energy Corporation.
Good afternoon, Mr. Rankin. Are there any other parties?
Not to our knowledge.
Go right ahead.
Thank you, Mr. Hearing Officer. In this case, Hillcorp is seeking an exception to the well density requirements in the Gobernador Pictured Cliffs gas pool to allow it to complete an additional well in the spacing unit. There's an existing well producing and Hillcorp is proposing to simultaneously dedicate an additional well, the San Juan 29.5 unit 61C well, which would be in the southeast quarter of the existing unit. We provided an exhibit packet that includes exhibits A through E. Exhibit A is the application. B is a self-affirmed statement of Hillcorp's landman, Mr. Carlson, who has previously testified and has had his credentials accepted by the division. His exhibits attached to his statement include notice area identifying each of the tracks, offsetting and spacing units identified that have been noticed, and the owners of interest who are affected, to whom notice was provided. Exhibit C is a self-affirmed statement of Mr. Shane Smith, an engineer with Hillcorp. He has previously testified before the division and has also had his credentials accepted as a matter of record as an engineer. He's got exhibit C1 through C5, which identify the basis for the requested approval to allow Hillcorp to complete an additional well in the spacing unit, which would allow it to recover additional reserves, preventing waste of resources. Exhibit D is the self-affirmed statement of my colleague, identifying that we have provided notice to each of the parties who are affected, along with an affidavit of publication showing that notice was published in a newspaper, identifying each of the parties by name who are affected. We ask that the case be taken under advisement and exhibits A through E be taken into the record.
The exhibits are admitted without exception. Mr. McClure?
Mr. Hearing Examiner, I'll have questions for the landman.
Okay, Mr. Rankin?
Mr. Carlson, I believe you are on the system. If you would, please put your image up and you can be sworn in.
Mr. Carlson, would you raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Can't hear you, sir.
You're on mute, Rob.
Yeah, you have to unmute your microphone.
Sorry, I do.
Okay, thank you, sir. Would you state and spell your name?
Robert Carlson, ROBERT CARLSON.
Okay, thank you. And have you previously been admitted by this division as an expert?
Yes, I have.
In what field?
Petroleum land matters.
Thank you. Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Carlson, I'm looking at a footnote in your exhibit number B. This is your self-affirmed statement on page 8 of 33. Are you familiar with the footnote I'm referring to? It's in regards to this spacing being standard.
Yes, the division director approval dated September 2nd, 1955.
Yeah, please provide me additional details in regards to that footnote.
Yeah, so basically, there was some discussion at the time in 1955 as to the spacing units that were applicable within the numbered federal units. And I say numbered federal units, for example, the 29 and 5, those unit agreements are unique because they actually outline specifically what the spacing units should be above the base of the Mesa Verde. And they require them to be 320 acres on either a west half or east half stand up. And so inside of the number of federal units, depending on who actually worked up a particular project. In most cases, you would see a stand-up being assigned to Pictured Cliffs producers. But there is kind of a mixed bag, again, depending on who, which landman worked up a particular recompletion or new drill.
Are you aware if the operator at the time ever actually requested and received approval for the non-standard spacing units or to change the spacing of the pool at the time?
Not that I'm aware of. Again, this is just the letter that I have that I've historically understood was the basis for the east half and west half stand-ups for everything above the base of the Mesa Verde, which would include the Pictured Cliffs. And this letter was received, it was in our files, it was received and it was provided by the commissioner at the time.
Is it your belief that all of Hillcore's picture cliffs are on 320 per those unit agreements?
Tough question to answer because I would say yes. It is my belief they should be all on 320 acres. But again, it is dependent upon whether the landman at the time for a particular recompletion was aware of the existence of this, whether they assigned a 160 acre spacing unit to the PC or the appropriate 320 acre spacing unit to the PC. So you see mixed examples.
Mr. Carlson, would it surprise you to know that 90% plus is on 160 acre spacing?
Doesn't surprise me.
But yet it's your belief that the standard spacing for this pool within these units is 320 acres.
That is correct, as it is very specifically outlined in the unit agreement itself. And if you look at the exhibit for the plat, which shows the notice area, you can see, I know that 90% figure you're providing, but you can see in this particular instance, the 3 spacing units directly to the south, which are comprised of all of section 16 and the west half of section 15, those are all 320 acre spacing units.
Mr. Carlson, are you familiar with the commission order where that unit was approved?
I have not read it recently, no.
Would it surprise you that this topic came up several years ago between Hillcore and the division in which this discussion has been had already?
I was not aware of that discussion, no.
If I were to tell you that that Hillcore needs an NSP before this simultaneous dedication can be approved, do you understand what I'm saying?
So we're disregarding the decision that was provided in writing by the commissioner at that time? Was that the decision that was ultimately made recently in those discussions?
Well, to be fair, I guess we'll afford Hillcore the opportunity to provide the note that it's referring to, that the division director had apparently approved September 2nd, 1955. Do you have that available? Is that within the case file?
I don't know if we actually included that as part of the case files.
If I were to ask for you to provide what you're referring to, do you know what I'm asking for?
Yes, I can absolutely provide you with a copy.
Okay. Directing your attention to page 12 of 33. This is your table breakout of like working interest owners and such.
For notice, yes.
Mr. Carlson, I'm looking at, at the table, like halfway down where it references section 15 and then it goes on to say east half. Is this a typo or am I misreading the map above, I guess?
That is a typo, yes. That should be west half.
Okay, do you think the, like the interest owner being Hillcore, is that accurate for the west half of section 15 then?
It is, yes.
Okay,
That particular spacing unit, even though it's within the federal unit, is not part of the participating area. So the ownership is comprised on a spacing unit basis, which Hillcorp owns 100%.
this is probably a question for Mr. Rankin, unless you're familiar with the notice, Mr. Carlson.
I'm probably pretty familiar with the notice. What's the question?
Was one set of notice provided or more than one?
It was two sets of notice. So the original notice that was sent, there was some miscommunication between myself and Miss Paula Vance. Again, it kind of stems from the understanding that we were dealing with a 160 spacing versus 320. And so the initial notice that was sent out was for all adjoining spacing units to the to the southeast of section 9. That inadvertently excluded the southwest of section 3 whenever you properly expanded the spacing to the 320 acre basis. And so we had to supplement the notice to also include Dugan in their ownership in the southwest of section 3.
Was all written notice received by each person?
It was.
Yeah, does that include this, oh, I don't know how to pronounce it, but like New Vidsa Resources LLC?
New Vida, yes, that delivery was
Oh,
confirmed.
Thank you, Mr. Carlson. Mr. Hearing Examiner, I don't have any further questions for this case.
How do you want to proceed?
I think we'll need to continue it for him to provide us with that. I don't know if it's the director or the commission at the time, but that approval letter.
Okay, Mr. Rankin?
Thank you very much, Mr. Hearing Officer. We'll plan to provide a revised exhibit packet that will include an exhibit referenced in the footnote 1, the 1955 letter or approval from the director of the commission or division at the time. And we will also revise this exhibit B2, I believe. I believe, Mr. McClure, the line you're speaking to Mr. Carlson about is the one I'm highlighting here. Correct? That
is correct, Mr. Rankin.
Okay, so we'll correct that to reflect west half and resubmit it with the addition of the approval from the 1955.
Okay, thank you, Mr. Rankin. And then what docket do you propose to move this to?
Well, I think we can do this with the division's approval to the May 7th docket, if that's acceptable.
Okay, we'll do the best we can to accommodate it.
Appreciate that. Would you like us to file a motion for continuance?
Definitely.
Okay. We'll get that filed. Expect to be able to do that today, Mr. Hearing Officer and Mr. McClure, and we'll also file the motion for continuance to the May 7th docket. If there's some issue with that docket, just let us know, and we'll take the next available hearing.
Okay, thank you, Mr. Rankin. We're off the record in that case. Mr. McClure, have you had a chance to take a look at case number 5 on our docket?
Unfortunately, I have not, Mr. Hearing Examiner. This
Okay,
case
so
took
then-
longer than I expected.
no worries. So then can we take it at the beginning of tomorrow's docket?
That works for me, Mr. Hearing Examiner.
Okay, and are your witnesses, will they be available tomorrow morning?
Yes, they will.
All right, what? Freya, what time are we gonna start tomorrow? You scheduled for 9. Are you planning on leaving? What does that say? I can't read that. Yeah. Will you be taking your equipment home then?
Boy, I take it home anyway.
You do anyway. Okay.
Yeah.
So it would be virtual then tomorrow?
No, I'll be come back.
You'll come back?
I don't live that, I'm on my tramway.
Oh, I did.
Yeah.
Okay.
So. The door's turning.
Okay, you're okay with that? Okay. All right. We will decide at the end of today what time we'll start tomorrow. I'm open to starting early. If the parties are willing to start early, our court reporter is willing to start at 8 o'clock in the morning. I know Mr. McClure gets in at 8, so maybe it would be 8:15 or something like that. But anyway, we'll talk about that at the end of today. Where we last left off, we had a witness who's no longer here. Come on back. And Ms. Bennett, you were going to review some information with Mr. Harper. Have you done that?
Yes, I have. And it turned out that we did not need to review the piece of paper I was
Oh.
holding up. Instead, what he brought up just now are copies of the applications that were filed that are part of our exhibit packet.
Okay, so what is the issue that we're going to begin with here?
The issue is the question that Mr. McClure asked, which is how did Avant determine the depth severances for each of its respective
That's-
bone spring applications?
I remember, and Mr. Harper was unable to have the data in front of him, but you do now.
Yes, yes, sir.
So tell me what you're looking at.
I'm looking at exhibit A1, which is our application.
Okay.
For case number-
A1.
A1,
application.
yes, sir.
In all 3 cases?
Yes.
It's the same application for 3 cases?
Well, it's case number 25827.
Perfect.
And
Is there
then
another case or just that one case?
There's three
oh, yeah,
cases altogether.
25829 and
3-1.
31. Yeah.
Right, but is it the same application for all 3 cases?
No,
Okay,
the 25827 is the first bone spring application and identifies the first bone spring
perfect.
bone spring depth severance. 25829 is the second bone spring application and 25831 is the third bone spring application.
Now, Mr. McClure was really not able to get answers to his questions. So are you okay with Mr. McClure asking those questions again now that this witness is
Definitely,
informed?
definitely.
Okay. Mr. McClure, do you want to go back to your questions now?
Thank you, Mr. Examiner, I do.
Go right ahead.
Mr. Harper, where are the depth severances located at in the Bone Spring Formation?
For the first bone spring in Avalon in our application, the depth severances lie between the stratigraphic interval of 78 or 7,894 feet to roughly 9,221 feet found on the Sam H. Snoddy Federal Number 1 well. That defines our Avalon and first bone spring sand interval. Do you want me to keep
Mr.
going?
Mr. Harper, what is that related to? Is that related to a formation top or is there a specific well that is tied back to?
Technically both. It's tied to a specific well, which is the Sam H. Snoddy Federal Number 1, API 30.025.27812. And for the Avalon and the first bone spring sand, those depths, again, 7,894 to 9,221 are identifying the top of the Bone Spring lime formation to the base of the first Bone Spring sand, which is the top of the second Bone Spring shell / carb in that well, reference well.
Okay, so you believe the depth severance to lay at the top of the first bone, or excuse me, at the top of the second Bone Spring sand. Is that correct?
I've identified the second Bone Spring sand using the same well to be 9,519 to 10,172, which is the second Bone Spring sand interval. It excludes the second Bone Spring shale interval based on that well. Does that answer your question?
the original, the way in which the way in which this depth severance was originally derived, is it due to a formation top, or is there a specific well that interest was sold in, if that makes sense to you?
The depth severances were originally derived per zone, i.e. the Avalon first, and then the second bone and the third bone spring based on my geologic stratigraphic correlation to identify the zones of interest. We identified those zones based on the snotty type log with given depths. And we proposed or identified the second bone spring sand interval based on that snotty, but to be a 640 acre unit drilling 1 mile laterals because there are existing second bone spring sand horizontals drilled in the north half of 26 by Coterra.
Let me re-ask my question, I guess. Avant itself is not who caused the difference in ownership. Is that correct?
That's correct, to my understanding.
Okay, what was the original cause of the depth severance, and what was that tied to?
Are you referring to the Coterra interest in the north half of 26 as depth severances?
Well, I guess that's my question to you. That might be the source, but I'm not sure. It would have come up as a part of Avant's title.
Okay, I think I understand.
Research.
So the way in which we proposed and planned the spicy chicken second bone spring sand as 1 mile laterals was because of the existing depletion that Coterra established in the north half of 26 based on their second bone spring sand intervals that they defined their interest based on their interest depths coverage.
And is it your testimony that those Coterra wells in the north half of section 26 is what caused the break in ownership?
I believe that's where the majority of their ownership lie, is in the second bone spring sand interval in the north half of 26. And that there are other owners who own above and below that interval.
Do you think that Avant's landman might be able to provide me a little bit more insight on where this depth severance was derived?
Potentially, yes.
Because for additional context, I understand the way you're tying it into the TVD of these wells, but what the division needs to know is where it was actually derived and where that top is.
Okay.
We're going to want your tie into a well, yes, but first is going to come where that depth severance actually occurs and what originated it.
Okay.
I guess, can you shed any additional light on that, or should I ask a different expert witness that question?
Probably best suited to discuss that specific depth severance with Tiffany Sarantinos.
Okay, thank you, Mr. Harper. In any of your direct testimony, did you include a clean breakout of all of the well costs and battery costs?
Not in my direct testimony, no. I believe that was in our reservoir engineering section.
Okay. In regards to Avant's Bone Spring 2 case, what vertical limit is Avant asking the division to force pull in regards to formation rather than TVD?
The second bone spring sand interval.
Thank you, Mr. Harper. Mr. Hearing Examiner, I don't think I have any further questions for this expert witness, but at some point I would like to talk to their landman, Ms. Sarantino's again.
Okay. Do you have redirect for this witness?
Very limited.
Go right ahead.
Thank you. Mr. Harper, do you recall the questions you received from Ms. Hardy regarding the Avalon slide that you prepared as a rebuttal slide?
Yes.
And do you recall that she asked you whether there were, or that she clarified with you that some of the wells are producing and some of the wells are being drilled?
Yes.
And are there wells that are being drilled that are in close proximity to the spicy Avalon wells being drilled in close proximity to the spicy chicken unit?
Very, very close, directly north by Civitas.
And is it, and those are currently being drilled?
Yes.
And then, do you recall being asked by Ms. Hardy whether, Permian could come back in and develop the Avalon?
Yes.
And do you remember being asked if Permian could come back in and develop the Lower Wolfcamp?
Yes.
Is Avant able to come back in and develop the second Bone Spring Shale?
Yes.
And would you intend to do that?
Absolutely. I mean, given today's commodity price, it's probably a high likelihood that we could incorporate the second Bone Spring Shale into this development or future development.
And did you originally not include the second Bone Spring Shale in part because Permian was not developing the second Bone Spring Shale right next door in Paxi?
Yes, that was a factor. They excluded the second Bone Spring Shale and their Paxi development directly to the east. We didn't originally include into our development plan for two main reasons. One, contrary to what they say about the Avalon, the second Bone Spring Shale is actually not being developed very close compared to the Avalon, further testimony. But B, the reservoir quality of the second Bone Spring Shale, in my opinion, is not that great. But I think as commodity price and economics would help overcome that lack of reservoir quality.
Thank you. That's all the redirect I have. Thank you very much.
Ms. Hardy, anything on that?
I have a couple questions to follow up on Mr. McClure's
Go right ahead.
questions, if I may. Thank you. Mr. Harper, regarding the depth severances, if we could look at Avant's application in case number 25829, which is the second Bone Spring application.
Yes.
And I think Ms. McLean is pulling that up.
Mm-hmm. 25829.
25829. Okay, and that is Avant's application to pool the second Bone Spring, correct?
Yes.
Okay. And isn't it true, though, that I think you said this earlier, the actual depth that you're pooling only includes the second Bone Spring sand,
Yes.
right? It excludes the second Bone Spring carbonate.
Second Bone Spring Shale / carbonate. Yes.
Okay. But the application states you're pulling the entire second Bone Spring.
Based on the depths provided. Yes.
And then, the depth goes down, the top of the second Bone Spring, it defines as 9519, right? 9,159 feet.
9,519 feet.
Oh, sorry. My glasses are not apparently 9,519 feet.
Yes.
Okay. And so that is for purposes of this application, how Avant is defining the top of the second Bone Spring, right?
Yes.
Okay. And then if we can look at Avant's application in case 25827, which is the application for the first Bone Spring.
Yes.
And that application states that Avant is pooling down to 9,221 feet, right?
Yes.
And that as provided here is the base of the first bone spring, right?
Yes,
Okay. So when you look at the two applications together, the, the, the base of the first bone spring as provided in this application does not align with the top of the second bone spring as provided in case 25829, right?
correct.
And that's because case 25829 actually excludes the second bone spring carbonate, right?
It does.
Okay, those are my questions. Thank you.
Mr. McClure, did that raise anything for you?
No, Mr. Examiner, it did not.
All right. May this witness be excused?
Yes, thank you.
All right. Let's recall the land person.
And Mr. Examiner, could we take a 5-minute break and just make sure she understands the question that she's about to be asked before we spend time on the stand?
Sure. Is there any objection to that?
No objection.
Okay, very good. Thank you.
Thank you.
Okay, I remind you, we're back on the record. It is, let's see what time it is. It looks like it's 1:23 PM. We're back on the record and we have recalled Miss Sarentinos.
Yes,
Okay, close enough, I
Yes.
guess. I remind you, you're still under oath.
yes.
Okay, so Mr. McClure, well, why don't you tell us, Ms. Bennett, what you reviewed with the witness before I ask Mr. McClure to begin?
What we were talking about was answering Mr. McClure's question. What I understand his question to be is there a title depth severance in addition to a geologic depth severance? And so that's what we talked about.
Okay, and you were, and Ms. Sarentinos, you were here in the audience listening to Mr. McClure ask Mr. Harper these questions. So hopefully you understand where he's going with this. So
Hopefully.
Mr. McClure, go right ahead.
Thank you, Mr. Hearing Examiner. Ms. Sarentinos, Martinos, where was the depth severance originally derived from? Presumably some sort of title exchange?
Yes, obviously I don't have my full title opinion here, but I do recall there being a specific depth severance to Katera that is at the base of the first bone spring to the bottom of the second bone.
Okay, and that's in relation to the north half of 26, you believe?
Yes, that's correct. For sure it was there. Yep.
Okay, and just to confirm, again, it's from the base of the first bone spring to the base of the second bone spring. Is that correct?
That is correct.
Hey, did you hear my question earlier to Mr. Harper in regards to what interval Avant would like the division to force pull for its bone spring 2 case?
Yes.
So if I were to ask for you to amend your self-affirmed statement to reflect Mr. Harper's response, do you understand what I'm asking for?
Yes, I think so. Yeah.
Okay, to confirm, what is your understanding, I guess, of what Avant would like the division to force pull?
I'm sorry, can you repeat that?
To your understanding, what interval is Avant asking the division to force pull in the bone spring 2?
We're excluding the top of the first bone to the bottom of the, or sorry, excuse me, the second bone, top of the second bone to bottom of the second bone shale.
From the bone spring 2 interval, is that correct?
That is correct.
Okay, thank you, Miss
Sarentinos.
Sarentinos. Yep.
Yes, thank you.
No further questions, Mr. Hearing Examiner.
Okay, Ms. Hardy or Ms. McLean? I don't know who's directing this. Is it Ms. McLean?
Yes.
Okay. Do you have any cross-examination based on what you just heard?
No, I don't.
Okay. Ms. Bennett, is there anything you need to clean up from what she just said?
No, I understand what Mr. McClure is requesting in terms of amending her self-affirmed statement to reflect the second bone spring sand.
Okay, perfect. All right. May this witness be excused?
Yes, thank
All
you.
right.
Thank you.
Let's call your last witness, Mr. Shane Kelly.
Thank you.
Mr. Kelly, I remind you, you're under oath.
Yes.
Thank you.
Thank you. Good afternoon, Mr. Kelly. If you wouldn't mind, excuse me, stating your name and by whom you're employed.
Yeah, my name is Shane Kelly. I'm employed by Avant Operating.
And how long have you been employed by Avant?
Since its inception in 2019, just about 7 years.
And what is your title?
I'm the Senior Vice President of Engineering.
And you prepared direct testimony in this case
That's correct.
and exhibits?
That's correct.
And I'm going to start sharing my screen in just a second here, but are there any exhibits? There is a change that you need to make to one of your exhibits, right?
Yes, I'm sorry, page 286. I don't see the exhibit number. I apologize. Oh, C1.
C1, yeah.
In the legend, I wrote that Paxi had an Avalon well. That should just be 5 first bone wells.
Okay, hold on just a minute while I get to that page. And so this exhibit here, exhibit C1,
That's correct.
and it's this indicator right here that the Paxi has 1 Avalon well and it should be 5 first Bone Spring wells.
That's correct.
With that change to your testimony, do you adopt your testimony?
It doesn't change anything in my testimony, is it?
Oh, I'm sorry, exhibits.
Oh, yes,
Okay, so you adopt your testimony and exhibits.
yes.
Thank you. I'd like to go ahead and ask you to give a brief summary of your direct testimony, including your rationale as to why you believe from a reservoir engineering perspective that Avant's plan is superior to Permian Resources plan.
Yeah, sure. Just going through on the first slide is kind of an overview of the 2 developments closest to Spicy Chicken between Permian Resources and Avant Operating. We took a look at the total.
Mr.
oil-
Kelly,
Yes,
if you're going to reference a slide, please tell us the slide number.
slide number, so 286, or would you like
That might be the
C1?
page number.
Okay,
But could we have the exhibit number?
C1.
C1, good. And in the future, just every time.
Okay,
C1, thank you.
no problem. So on this slide, we're just showing the 2 developments in the past. And as you can see from the chart on the right, we actually had pretty similar development, even though our plans were slightly different in each unit. This is just showing the both operators have been consistent in the area. They know what they're doing. And we've proven that we can operate in this area pretty well.
Thank you. And then turning to exhibit C2, can you just give a brief summary of exhibit C2?
Yeah, C2 is just a little recent history. We've been operating in this area for a long time under the Avant Operating 1 tag, recently sold last year. Just started up operations on Avant 2 back actually February 14th, Valentine's Day. We have the same team in place as the last company. Same group has drilled all of the wells at AO1 and the current wells at AO2. And just kind of showing our history as an operator. We started off extremely well at Avant 2, breaking a basin record for 1 mile laterals. In 2025 with Liberty Frac, we were the most efficient operator out of 63 operators in the entire US. So proven operator in the area, and hope to continue to do that.
Thank you. Okay, let's turn to your next slide. And this is exhibit C3. So if you could briefly explain this slide to the examiners.
Yeah, exhibit C3 is just the current pooling application wells for both Permian Resources and Avant Operating 2. As you can see, and has been discussed, we feel like there's going to be some significant reserves left behind by Permian Resources not pooling the Avalon or the deeper Wolfcamp at this time, when Avant plans to do that in the near term to bring those reserves forward. So this is just a chart of what we feel the total reserves lost would be to Avant as the majority working interest owner.
And then turning to your exhibit C4, if you could briefly talk through this exhibit and what your primary takeaways are from this exhibit.
Sure. On C4, this is really a midstream overview. One of the most important pieces to the puzzle out here. We've already been working right away for each gas, oil, and water. Oil is pretty much under contract, and right away is almost in hand. Gas, we've been working with multiple service providers. It's one of our main goals to set up more than one gas takeaway option, just to secure flow on each of our new wells. This contract we're kind of under a CA right now, so I can't discuss the operator, but we are very close to signing this contract, and this would allow us to flow sour gas through their system and down into their AGI, as well as our secondary option will also allow us to flow sour gas, which is a big deal with the Avalon. It's just too sour out here to treat. So that is going to save us a ton of money and make that formation extremely economic. With water, ever since AO1 and the Cupo, when we got burned by a midstream partner who was not able to take our water, which affected our first Cupo wells pretty greatly, and they never really recovered. We have since taken water into our own hands as a company. We've been doing that for the last 2 years. We already have a pond built off to the east, our Quail State Pond, and then in progress recycling facility just east of Spicy Chicken that is fully permitted and ready to go pending this pooling hearing. We'll start building that immediately and be ready to operate.
Thank you. And a moment ago, you were talking about sour gas. Is that the same thing as H2S?
That is, yes.
And so Avant already is planning for H2S contingencies. Is that right?
That's correct. Not only in the Avalon, but the first bone out here also has sour gas that can go down the line.
And it sounded to me like, and feel free to correct me if I'm wrong, that you have two different paths forward for H2S.
That's correct. We have multiple paths forward. Not signed, but very close on both.
And will those options be less expensive than what you understand Permian Resources H2S solutions to be?
At this time, from their exhibits, they said they're committed to trace, I believe, and I don't believe they have a sour system or a sour AGI well in service yet. I do think they're working on it, but it's not supposed to be ready for quite a while.
And an AGI well is an acid gas injector?
That's correct. Acid gas injection, almost like an SWD, but for sour gas and CO2.
And so you feel that, do you feel that Avant is ready to begin drilling the Spicy Chicken wells?
Yes, we are. We should be ready within the next 2 to 3 months, depending on a couple of right-of-ways that we're waiting on.
And do you know if Avant has permits pending with the BLM, APDs pending with the BLM?
We do. They are at the final stage and they are just waiting on this pooling order and then they will be approved.
I'm turning now to your exhibit C5. And I wanted to talk about this exhibit because Mr. McClure had some questions about the non-standard unit exhibits that we showed earlier today in Ms. Sarantino's testimony. Do you recall those questions?
I do.
And in her testimony, we had shown two units instead of one non-standard unit and 2 CTBs. Does this reflect the development plan that AO2 is proposing?
This slide reflects our plan. Yeah. I believe Ms. Sarantino misspoke a little earlier. That was a mistake on the slide. We only have 1 CTB and full disclosure, this slide was made when we didn't have the full picture of what Permian Resources' new surface plan was. But now their surface plan is pretty much identical to our plan, if not right on top of it. So we're planning on doing, the same thing as them, 1 battery and 2 pads to limit surface disturbance. So a lot of these costs and numbers on here are based on our previous understanding of what we thought they were doing. So
And now, I'm sorry.
I'm sorry. I think that's been discussed in previous testimony. So
Great. And so you had mentioned that the Avalon is prospective in this area. Do you recall
definitely, 100%.
that? And do you have concerns if the Avalon is not developed in this area?
I would definitely have concerns just because it's a lot of reserves that are left behind. It's proven to be a really strong formation everywhere that it's been tested in the north. And that's why every operator is doing it now. And it took a while for midstream to catch up with the sour gas, but there's a lot of midstream providers that now have an AGI, and it's possible to drill up the Avalon in the near term instead of having to wait or try the treating option, which we've had to do down south, and it just doesn't work. It's too expensive. And that's a main reason why that Exxon well just didn't work. They weren't prepared for the sour gas, and we're trying to treat, and it was too expensive.
Okay, thank you for that. Is there anything else you wanted to say about your direct testimony before I turn to our rebuttal testimony?
No.
So turning now to the rebuttal testimony that you prepared. You prepared a self-affirmed statement in support of your rebuttal testimony, didn't, right?
That's correct.
And
C5 is not in evidence.
yes, and I have a chance to try to
Of course, of
admit it if I want to.
course.
Okay. Thank you for the reminder, though. So let's look first at your rebuttal exhibit C1. Do you see that?
Yes, I do.
You say B1?
C1, sorry, I'll try to enunciate a bit better.
C.
Mhm.
Say it again.
C,
C.
as in cat.
I want to make sure the court reporter heard it because I did. Oh, you're looking on a screen. How clever of you.
So C1 is in response to the Permian Resources exhibit. I think there's C11, slide 22, where they try to point out that there was 45% degradation due to depletion off their original Paxi well in the first Bone Spring sand at 1,600 feet. Working through this basin for a long time, 1,600 feet, there has never been any kind of degradation like that ever. If you were to say maybe 300 to 500 feet offset, you could see that kind of degradation, but at 1,600 feet, that's more than enough to not have any kind of depletion effects, which we did at Cup O directly north. We actually came in a little tighter at 1,500 feet. And as you can see, that child well, which is highlighted in green in the top right chart, was actually our second best well in the entire unit, better than a couple of the edge wells. And that tells me there is absolutely no degradation from and coming in at 1,500 feet. So that claim is just not backed by fact in the basin. Been offsetting wells for 10 years and I've never seen that kind of degradation. So I'm just not sure where that's coming from. And I don't have all the backup data that he used to come to that number. But I did look at the Paxi wells, their child well that had the 45% degradation. If you were to see heavy depletion, you would have noticed it in the IP rates. That well actually had pretty similar IP rates on public data than the next two wells next to it. So unless that original well was depleting the entire section, then there's just no evidence of depletion. More likely with their down spacing pattern in that first bone, the wells were just a little weaker than the original, but the wells are still very good and very economic at the 5 wells per section that they did, as well as our 5 well per section Cup O. Then the bottom right chart is just showing cumulative oil plot, a couple of units off to the east that only did 4 wells per section. You can see they're just not producing all the reserves in the first bone. So that kind of shows that 4 well per section is just not the right number. And 5 is the best option out in this area.
And just to reiterate, 5 is what Avant is proposing, is that right?
That's correct.
And what is PR proposing?
They're proposing 4 with their first well coming in at 1320 spacing, which is tighter than the 1,600. They claim to have 45% degradation. So if that was the case, then I probably wouldn't do that. But we have that same plan of coming in 1320, and that should be more than enough to not see much degradation at all.
Great. And then is this the backup data that you prepared to support your exhibit C1?
That's correct.
Okay, let's turn to your rebuttal exhibit C2. Are you there with me on rebuttal exhibit C2?
Yeah, C2 is rebutting their C11 as well, but their slide 23 where they did the same kind of analysis in the second Bone Spring sand. We again went up to our Cup O where we came in 1,500 feet. You can see early time, there's just no evidence of depletion. There's no muted IP compared to the edge well, which tells me it's not a degradation issue. It's more of a well spacing issue as you start to see these wells diverge over time. That's because the blue well there, the 501 is an unbound well versus the 502, which is obviously sandwiched between some pretty old production in the legacy parent well there to the east, and then our new 501 well. And these 2 wells even came in underneath 2 east-west second Bone Spring sand wells. And we had to be careful with how we fracked that, but still with all of that, these wells are very strong, actually ahead of the Paxi second bone wells, which were at tighter spacing, so that does make sense. But I'm just not seeing any kind of degradation, especially not the 48% that they're trying to claim. So.
Great, thank you. And I'm scrolling past page 37, but that's your backup data for the wells you used.
That's correct.
And now I'm on rebuttal exhibit C3. Are you seeing that?
I am.
And can you describe that exhibit, please?
Yeah, this is an exhibit showing the Permian Resources pooling application plan in the first bone and second bone shale. The second bone shale has not been widely tested in this area. This was one of the closest, I think this was the closest place I could find where someone had done the 4 wells across the first bone and the 2 shales underneath it. And you can see where they're just not producing more oil by doing that. The first bone is just so prolific in this area. The Paxi wells, the Cuppo wells have been really big. There's been some other ones off to the east that have been very big first bone wells. That by dropping a first bone from 5 to 4 and trying to replace that oil with 2 shales and a weaker target, it's just not working that we've seen. I know PR has had some success off to the east in their Robin, Riddler, Batman units in the second shale, but the rock just looks a little bit different over there. I think as a team, John and I both agree that the second shale is a viable option off to the east, but we just haven't seen it produced in this area yet. So that's why we haven't currently incorporated it into our development plan with the, as John stated, with the uptick in commodity price. I think we may rethink that, but you never know what oil is going to do. So when we proposed this, I think 5-6 months ago, we were in a very different world in terms of oil price.
And just this square here, this table here that shows AO2 pooling with 5, that's your current proposal, right?
That's correct.
And the PR pooling, that's their current proposal, is that right?
That's correct, yes.
Is that replicated in Paxi?
No, Paxi, they did the 5 wells per section in the first bone. And like I said, those are very strong wells, highly economic wells. So I'm surprised they're backing off that plan.
And I'm scrolling past page 40. That's your backup data for the C3?
That's correct.
Okay, now we're looking at exhibit C4. And can you describe this exhibit and what your intent was with this exhibit?
Yeah, this is just an exhibit showing the 4-string Capitan Aquifer R11Q map. This is the area highlighted in yellow and blue that we are required to run 4 strings of casing. This has been a known thing in the area. I believe Paxi were 4-string as well, but we received the updated PR AFEs that look suspiciously low to us. And we started digging in and realized they are not accurate. They only have a 3-string design, which casing can get quite expensive. And that can cause your AFE to go up significantly. So they've had multiple opportunities to fix this issue. And they've used a lot of these low AFE cost estimates to try to make their wells look far superior than ours. And that's just not the case. It's not accurate data. We've tried multiple times with the SLO and BLM to get a waiver on the 4-string, but they have told us they will not budge in this yellow area whatsoever. So unless they have different information, I'd be shocked if they could 3-string these wells, especially since Paxi wasn't 3-string.
Thank you. And turning to exhibit C5, this is the rebuttal exhibit that is not yet been admitted. And so if I may, I could provide some information about why it's a proper rebuttal exhibit.
Just to be clear, what's the objection to it?
The objection to it is that these are adjusted AFE amounts that Avant is providing only here in this slide for purposes of rebuttal. And Mr. Kelly's statement states that they adjusted their AFEs because Permian Resources sent out updated FAEs a couple of weeks ago or a week or 2 ago. So the objection is that we don't have any actual AFEs from Avant that show the amounts in these tables. We can't do a line by line review. They haven't provided actual AFEs. They haven't sent them to any parties. So that's the objection.
Thank you. before I ask you to respond to the objection, why is this relevant?
This is relevant because, as Ms. Hardy just noted, Permian did on April 10th, I think it was 2 days or 3 days, business days before the hearing, exhibits were due, sent out revised AFEs with lower costs. And Avant, of course, has lower costs given the passage of time. And so this exhibit goes to show that Permian Resources comparison of costs does not reflect the current state of affairs.
So the evidence is relevant. The question is its reliability. So let's hear some foundation for reliability, and then I'm going to let Ms. Hardy voir dire the witness before I make a determination.
Thank you.
Go right ahead.
Mr. Kelly, did you prepare rebuttal exhibit C5?
With the help of our drilling and completion engineer, yes.
And are the figures that you show, so first of all, there's a set of rows that are labeled Avant. Do you see those?
I do.
And those figures, tell me how you derived those figures or how those figures came to be on this exhibit.
Yeah, we usually update AFEs before we go drill. In this case, we decided to update them for the hearing because of the AFEs we received and the exhibits where they were, calling out a lot of our AFEs and saying our wells were uneconomic and that we were wasting a lot of money, which just wasn't true. So we felt like we needed to update the AFEs sooner than we normally would. Like I said, we proposed these quite a while ago. We had set a little bit higher mark due to not knowing what tariffs we're going to do to steel. Being a small company, we like to stay on the conservative side to make sure that we're doing the right thing for our investors and drilling the best wells possible. So this just describes the world as it is today versus 6 months ago, and we're in a very different price environment.
And are these numbers that are reflected on this table, numbers that you and the team developed and are able to be verified internally at least?
Yeah, that's correct. These are in line with what we're drilling right now, as well as the most recent completion estimates that we've gotten from Liberty Frac Crew, as well as we've already ordered most of the facilities for this area. So everything here should be the most up to date as today.
And so these numbers are based on actual data, for example, based on the materials that you've already ordered.
That's correct.
Those are the only questions I have.
Ms. Hardy? Did you want to voir dire the witness?
Yes, I do. Mr. Kelly, so the table does not include all costs that are shown in an AFE, does it?
It's not broken out, no.
It only includes high-level costs for each category.
That's correct. That's correct.
And you haven't provided anywhere in your exhibits a breakdown of the costs that would be listed under these categories in a complete AFE, have you?
No.
So there's no way at this point for Permian Resources to review the cost included under these categories to determine whether they're accurate, is there?
That's correct.
Those are my questions.
Ms. Hardy, does Permian have AFEs in their exhibits?
We do.
We do.
And we
Are
have the-
yours broken? They are broken down.
Yes, they are. And Avant has AFEs as well in their original exhibits. But then they provided this table that is not,
Broken down.
they've adjusted those costs.
What would it take, Ms. Bennett, for your witness, maybe it would be tomorrow, could present something more in the line the way Permian did? I don't mind revised AFEs if that's the current state and he's willing to testify to it under oath, then so be it. But I am having a bit of a problem with the lump sum sort of number. What can you do about it?
I would like to confer with the witness, but if at all possible, we will provide
Okay.
revised AFEs tomorrow.
That sound fair, Ms. Hardy?
As long as we have an opportunity to review them and question the
Of
witness
course.
and understand that they still haven't been provided to the interest owners. AFEs need to be provided to the interest owners who you are pooling.
And Permians have been.
Yes,
And the original ones were from Avant.
They were.
These are just revised ones. What is, how old? Let me just ask the witness.
Sure.
The AFEs in your original exhibits, when were they calculated?
Yeah, I believe those were back in October of last year. It's been a while. Yeah, we proposed this pretty early, so.
And Ms. Hardy, how old are your AFEs?
We sent updated AFEs a couple of weeks ago.
Oh. Okay.
That's, yeah, to the interest owners.
Okay. I mean, I could, I'll discuss this with Mr. McClure, after today's hearing is over. And before we come back on the record tomorrow, I'm assuming we're going to, it's 2:00, so. But maybe we won't, I don't know. But I'm gonna reserve judgment. And I do see the value of Permian being able to look at the breakdown and form cross-examination based on the breakdown where they cannot on lump sum numbers like this. Mr. Kelly, these numbers, for example, the first one, column 3, lateral length, row 1, 7,500. How did you come up with that?
Well, that's the lateral length of the wells.
So that's
Yeah.
an AFE.
Yeah.
Sorry. Okay.
Um,
That makes sense. How about the next column over the 3 million?
Sure. I mean, I think I can get you guys the AFEs tonight. That way you guys can review them. They're made. We just didn't have a chance to get them into the packet because of just the timing. But they are made. I'll have our engineers send them over later today so they can review them before tomorrow, if that helps.
Well, I mean, you won't be able to introduce them otherwise, so it may help you. I don't know. But what about the, Ms. Bennett, do you want to address the assertion that these will not have, even if it's tomorrow, these will not have been provided to the mineral interest owners?
Yes, so first of all, Permian only provided the revised AFEs to Avant on April 10th, which, as I mentioned, was like 3 days before the hearing exhibits were due. But even putting that aside, the operator has an obligation to send out revised AFEs or the current actual cost prior to drilling a well. So even if everyone was under order, assuming an order was issued, at that time, everyone will get a revised AFE. So it's a matter of timing, not a matter of like legal insufficiency.
All right, I understand. So as it is now, this exhibit is still not admitted into evidence. I understand the objection. I sustain the objection in the form that it is here. So you're subject to recall, okay? If in fact you're able to provide this information tonight, that counsel for Permian gets it, they get a chance to review it. I mean, they have their witnesses, so they can do that. And we can pick that part up tomorrow virtually. You can be wherever you need to be. And we'll deal with that exhibit tomorrow and its admissibility. Ms. Bennett, is there anything more for this witness? Go right ahead.
Yes, thank you.
Go ahead.
Thank you. So, Mr. Kelly, I appreciate you walking through your rebuttal slides, but those weren't the only concerns you had with Permian's slides, right?
That's correct.
So let's take a minute and walk through the Permian slides that you had questions or concerns about. I think so I have C2 up here. Did you have a comment or concern about this slide?
No, not on this one. Just that their application wells aren't covering the Avalon or that lower Wolfcamp, which is concerning to us.
And weren't you intrigued by the fact that the Avant proposal looks very similar to the Paxi current plans?
Yeah, they're pretty similar. We've tested the 5 wells per section in the first bone and second bone, know it works. We just kept with that. We've drilled 6 wells in a section in the third bone. We did agree that, the plan to drop a couple down in the Wolfcamp upper is the right play here. So we did that as well to maximize reserves.
This now is Exhibit C3. Did you have any concerns with these slides, or did you feel that these slides were in fact helpful to Avant?
Yeah, no concerns here. I mean, just to point out, the Cupos are, the top wells on the left graph there, and they're clearly going to overtake the Paxi. So this just proves my point from earlier that we're both solid operators in the area and both have the experience and capability to drill spicy chicken.
And would you say the same thing is true for, or this is the second page of C3. Did you have any concerns or questions or comments? Not questions, but comments about this slide?
No, this is just showing the second Bone Spring shale, and you can see there's really not any wells that close to the Paxi. Most of them are quite far away in different rock. So,
And do you feel like that what's your takeaway from that in terms of the Avant development plan?
I think we have the correct development plan for the area. It's been proven to work in both Paxi and Cupo. And the second shale is something we can incorporate later if we feel like we should. But as of today, I feel like we have the right plan.
This is the third page of Exhibit C3. And this is a comparison of Permian's second Bone Spring sand versus its peers. And did you have any comments or concerns with this slide?
No, just the Cupos are clearly the best wells on there. I'm not sure if these were normalized correctly. And Varus, and no fault of Permian Resources, has the wrong data on lateral length. So it does screw with the normalization unless you dig into the frac well files, which is not normal to do on every single well.
Yeah. And this is the third Bone Spring sand Permian comparison to the peers. And did you have any takeaways from this slide that you wanted to point out?
No, a lot of good wells, pretty consistent. The Della EOG wells were actually drilled by myself and John Harper, so we're very familiar with the third bone in the area. Those were pretty early on and considered. The Wolfcamp Classics especially was considered a bit of a step out at the time. So very familiar with both the Wolfcamp upper and third Bone Spring targets in the area.
And just for the sake of reference, that EOG Della well is this top best performing well on this curve. Is that right?
I'm pretty sure the colors are
Yeah, the colors are
coming in. It looks more purple than the name, but yes, I'm pretty sure it's that one.
And that's the one that you were involved in drilling.
That's correct.
And then the Wolfcamp A quality versus peers. Was there anything on this that jumped out at you?
No, not really. The Della well is missing from here, which was one of the first classics. I think it was a really strong well. It would have performed pretty well on this chart, but is not on here. Besides that, we just had the Sandrine that we did off to the east in a pretty big package. But like I said, I think it's the right plan at Spicy Chicken, and we plan to incorporate there, just like Permian Resources is planning to.
C4, skipping. So C5, this slide is entitled Permian creates much greater value across all primary targets. Did you have any concerns with this slide?
Yeah, I just don't have the backup, and I'm not quite sure where these numbers are coming from on this slide and the next slide, especially. The numbers just aren't making sense if you scroll down for me one slide. Their PR recovery per well is more than double the Avant's. I don't see any reasoning that would be true. And there's just no backup data, so I can't go in here and confirm what's going on. But this definitely is not making too much sense to me.
And were you concerned at all about the footnote in footnote 1?
Yeah, the footnote about actual results will differ materially. Yeah, that's I mean, that's not very comforting, obviously. It's hard to trust the numbers on the page when that's on there. So I'd rather see the backup and see where this is coming from.
Thank you. And then this is exhibit C6, which is the U-turn well optimization. Did you have any concerns or comments on this Permian exhibit?
Yeah, Permian's been drilling a lot of U-turns as of late. I know a lot of people are. But this is in section 23 where we control over 90% of the interest. We feel like we can get wells in the ground with less risk and quicker at 1 mile. And as well, we could add an extra well here. With the U-turns, they're only doing 4 wells per section. The second bone is one of the best targets in this unit. And I feel like they'd be creating quite a bit of waste by not adding that 5th lateral, if you will, in this section. And again, I don't know where these numbers are coming from, observing a 25 decrease in time, reduction in CapEx compared to what? There's no data to support any of these slides. So.
Thank you. Now we're looking at the AFE summary table, which I think we didn't have any comments on that one. Turning now to the exhibit C8. This is a slide that Permian prepared that I understand is comparing and contrasting your first Bone Spring development plan with their first Bone Spring and second Bone Spring development plan. Did you have anything you wanted to say about this slide?
Not much. This is just pretty far away. We haven't seen this done kind of in the recent vicinity of PAXI. I'm surprised they didn't incorporate at the PAXI if they like it so much, but for now, like I said, it's something that we're thinking about. We could come back and do, but we did not incorporate in our initial application.
This, I believe, is a continuation of the slide C8, so your comments apply equally to this slide.
Yeah, that's true.
Does this show, a moment ago, you said that the Batman and Robin were a ways away. Does this help understand what you mean by a ways away?
Yeah, it is. I mean, not only that, the rock is just different. The second shale does look quite a bit better over here. Like I said, I think we're going to incorporate it into our packages out to the east. But as you move to the west, it does kind of degrade. So we're just not sure if it's going to work the same way as the slide is showing at this point in time.
And when you say the second Bone Spring shale looks better over here, you mean over in Bain and Batman?
Yes, that's correct. Batman, Robin, Eileen, and Riddler. Yeah.
Okay. I just wanted to make sure that you weren't saying here as in spicy chicken, but you were saying here as in the wells that are identified on that slide.
That's correct.
Okay. Okay, now I'm at exhibit C9, which is a slide addressing the Avalon development in this area. And I know Mr. Harper spent a good amount of time talking about some closer wells, Avalon wells that are being drilled, that are being developed. But I wonder if in your review of this slide, if there is anything you wanted to comment on with respect to this slide.
No, I think this shows with the Lee unit and the Sandra Jean that we've been testing this probably the most aggressively out of any operator. And we'd like to continue to do that, Cuppa. We have the experience. We know exactly what to expect. And then, some of the numbers and their rebuttal exhibits about H2S and everything clearly shows that they're not sure what they're going to get out there because they're not even close to being correct. But we have that data. We know exactly what to expect, and we've prepared for it over the last 6 to 8 months.
Great. And C10, on C10, did you have any comments on C10 and the addition of the third Wolf Camp well?
Yeah, they're adding this Wolfcamp well, but they're failing to put on the third Bone Spring sand wells on the same map, which is going to come with depletion as well. And if they believe in that 45% degradation, then I don't know how they can say this is a full parent well that's super far from an existing well when you have a third bone producer right on the edge of that unit. So it just doesn't align with the rest of their exhibits.
And when you say a third bone producer, that's in the PAC-C unit, right?
That's correct. Yeah.
Not sure if this is the second page of that slide, anything to?
Oh, yeah. Yeah, the Cupos we did operate. We did not operate the Grayling or Alpha Wolf, which I think is what they're pointing to. Again, I'm having trouble seeing some of the colors. But Cotera had already taken over the operations at that point. And Cupo is where we struggled a lot with midstream providers not providing us with the service that they had promised. We had to bring on wells and then basically choke them back to nothing for 6 to 8 months while we had to go build out our own pipeline in the area. Because we were one of the first kind of movers in the modern horizontal. There were some older wells, but it came with a lot of really old pipe that just could not support 3 new modern 2-mile wells. So that's really all I have to say about those wells.
And so, in your opinion, then, is the data here on the Cutbow wells reflective of that well's potential?
Probably not. No, definitely not. They should have been a lot better with the kind of pressure, but having to choke them back, we were never able to get enough water off to make those wells truly perform how they are, how they should have been, which was unfortunate. But like I said, we've remedied that situation by completely taking over water ourselves, so we never have to deal with having to shut in again due to a midstream provider.
And so that constraint on Cutbow was not an AO2 or an AO1 constraint. It was an external constraint.
That's correct.
On Exhibit C11, this is a Permian slide that is suggesting that your extra first Bone Spring well will create economic waste. Did you have any comments or oh, this is the one that you did a rebuttal slide for,
Yeah,
right?
this is,
Okay.
but I mean, one more thing on these charts up here, I have no idea what they're normalizing these charts to. I don't know if they're 2 miles or if they're normalized to match the table, which is probably what I would expect. But if that's the case, the degraded well in blue here has already cumed more than the EUR they're trying to state for our Avant well. That's also at the same spacing they proposed. So this slide makes absolute no sense, and it's just trying to show that we're going to drill a super uneconomic well without the backup data or any kind of fact. So kind of the same thing on the next slide. They did the same thing. You can see those wells. If this is normalized to 2 miles, that degraded well is made over 300 MBO, but they're saying our 1 mile is only going to make 165. I mean, none of this makes any kind of sense in the reservoir engineering world. So I'm not sure where these are coming from.
Great, thank you. And you reviewed Permian's rebuttal slides, right?
That's correct.
And you understand that those have not yet been admitted into the record,
That's correct.
and except for C12 and 13, I believe, which I'll pull up. Just one second, I need to stop sharing and then I'll find them. Let me look at them real fast to see if it's even worth sharing. Okay. And let me just double check my notes, which ones we did not object to. I'm gonna go with C12 and 13. I don't have my notes right in front of me.
I think it might have been 13 and 14.
Okay, that's right, 13 and 14, thank you. So let's go, I'm gonna turn to C13. So you had a chance to review this rebuttal slide, C13.
Yes, I did.
And it's a rebuttal slide that purports to rebut some extrapolated volumes that you prepared.
That's correct. It looks like he was throwing an extra 17% on the 3 wells that we extrapolated at Cupo, but that 17% was noted to be when you go from 5 wells per section to the 6 wells per section, we were seeing a 17% degradation. So Cupo is only at the 5 wells per section, which is how I got to my 2%. So the added 17%, which is not necessary. So wasn't trying to mislead. I think it was just in one of my footnotes and maybe misunderstood.
Thank you. With that misunderstanding, this does not accurately reflect what your intent was in your slide. Is that what I'm
That's
hearing?
correct. Yeah.
Okay. And then turning to C14, is this a similar situation where there was a misunderstanding of your numbers, or what's your?
No, I mean, this is using the older AFE. I think, that's where the 44 million is coming from, which is another reason we wanted to get the updated numbers, because there's a lot of slides that are bringing in value to the equation, and using the wrong numbers is, I think, unfair to us as an operator when that's not the reality that we're in today. As far as the delayed volumes, I mean, they are correct. Like I spoke to a little bit earlier, we had a really tough issue with the first Cupo 600 wells. We weren't able to open them up, and that's what's causing that issue, that delayed volume. But like I also said, now that we control our own water, we have multiple gas midstream providers that are going to take our gas, and oil has always been solid in the area. And if not, we can truck oil if needed. This shouldn't happen again. So I understand what he's saying. It's always nice to get money up front for your investors. But in this case, we were put in a situation where that just wasn't possible. But that's not the go forward for Avant Operating 2.
And when you say the delayed value, that's the calculation that's in the lower right-hand side of the slide?
Yeah, I believe so.
And would that also apply, in Avant's opinion, to the delay in addressing or developing the Avalon?
Definitely. Like I said, it's hard to get a midstream provider out there that can take the sour gas. It's just not treatable. You won't make any money doing that. So by delaying that Avalon, which is a really strong formation and a very, very economic formation due to the lack of water that it produces, would definitely hurt Avant as a working interest partner, as well as the other working interest partners.
And would that same calculation be present for the lower Wolfcamp
That's correct. Yeah.
and the upper Penn?
That's correct. Being a smaller company at Avant, we like to produce whole units as quickly as we can to bring value forward for us as a company. It's usually not as important for the larger companies. They have a lot of money, but for us, it's very important. So we get after units pretty quick once they get pooled.
Thank you. Before I turn you over for cross-examination, is there anything else you'd like to add?
No, not this time.
Thank you.
Ms. McLean?
Actually, me, Mr. Examiner.
I don't know who to call, so.
I know, it's fair. So this one is me. Good afternoon.
How you doing?
Good, thank you. Mr. Kelly, earlier when Ms. Bennett was first questioning you, well, let me ask it this way. You agree, or Permian Resources is pulling the Avalon here, correct?
I am not sure.
And Permian Resources is pulling the Wolf Camp, correct?
I believe so, yes.
And so they could come back to develop the Avalon with infill wells, correct?
Correct.
And they could do the same with the Wolf Camp, right?
Correct.
Okay. And Avant here is not pooling the second Bone Spring at all in the north half of section 26, is it?
No, it is not.
So Avant can't develop that acreage with infill wells.
Yes, we can.
Well, you'd have to come in and pool it first, right?
Correct.
Okay. Avant has not provided, well, you have not provided in your slides, an economic analysis of your development plan in comparison to Permian Resources Development Plan, have you?
No, that's not usually in these packets.
You've only compared production volumes, correct?
That's correct.
And if we could please look at paragraph 8 of your direct testimony affidavit. Ms. McLean will pull that up. Paragraph 8.
It is here.
And you state in paragraph 8 that Avant's applications will result in greater total recovery, correct?
That's correct.
And in that statement, you are assuming that Permian Resources does not drill infill wells, correct?
Correct.
And none of your reservoir engineering exhibits discuss Avant's Grayling or Alpha Wolf developments, is that correct?
My exhibit, no. Yeah.
And those are 7 to 10 miles north of this area, right?
I guess I don't have a map in front of me. I'm sorry.
Let's look at your direct exhibit C1. And here, you're showing a comparison that you expect or that you're projecting, correct, between Permian Resources and Avant's developments, right?
No, this is not a projection.
Okay, so this is what you're looking at historically?
Yeah, this is actual production.
Okay, and you were relying there in the graph on the right on Avant's Cutbow total oil, right?
That's correct.
And Avant did not develop the Avalon at Cutbow, correct?
Not before we sold. We were planning to.
And Avant did not develop the Wolf Camp at Cutbow either, correct?
That is also correct.
We can look at paragraph 10 of your affidavit, please. Your direct affidavit. And in paragraph 10, you state that Avant's plan results in less surface impacts, correct?
That's correct.
And you refer to your direct exhibit C5, right?
Yes.
And I just want to be sure it's clear that you're relying there on Earthstone's original development plan for this acreage, correct?
As we understand now, yes.
And you understand that that's been changed.
I do now, yes.
And let's look at your exhibit C4, please, on direct. And Avant, as shown in this exhibit, does not have any existing operating units in adjacent sections to the spicy chicken development, right?
We have 2 adjacent operated units in the Thai Curry and Triple Stamp.
The Thai Curry wells are not drilled though.
Oh, sorry.
Right?
Correct. Yeah,
Okay. They're only permitted?
correct.
Okay. And the Triple Stamp wells are not permitted?
I
currently,
actually believe they are permitted, but not drilled.
And Permian Resources Paxi wells are operating in the adjacent section, correct?
Correct.
You've testified regarding H2S, and stated that Avant knows exactly what to expect. That's my understanding of your testimony. Is that correct?
Yes.
Okay. What concentration of H2S does Avant expect here in the Avalon?
I mean, that's proprietary information. We don't usually give out to people unless we're working a deal with. I'm not sure if I have to answer that.
If it's proprietary, it's protected by the Trade Secrets Act and so would not be subject to a question on cross-examination.
Okay. Are you saying that it
I
is
I object,
proprietary?
and it is proprietary.
You are saying that?
Yes.
Miss Hardy, what do you think?
Well, I guess I can question about the fact that they've made a big point of knowing exactly what to expect, and they're not saying what they expect.
You can certainly bring that out. Yeah,
Okay,
of course.
okay. So
That's
Mr.
no-
Kelly,
It's noted.
okay, so you can't state at this point on the record here, what Avant expects the H2S concentration to be, right?
Correct.
Okay. And if you can look at your AFEs for the Avalon wells, which are in Exhibit A24. Okay. So with respect to the casing for the Avalon wells that Avant is proposing, don't these AFEs show that there will be P110 casing?
That's correct.
And P110 casing is not corrosion resistant, is it?
We use a carbon steel version of the P110. Similar cost, but does help with some sour. Not all the way up to the T95, but we don't use that unless we see 30,000 plus parts in H2S, which we have not seen in our Avalon wells yet.
And with respect to the Avalon wells you're referencing, none of those are located in the immediate adjacent sections, correct?
That's correct.
Is it your testimony that the cost included in these AFEs cover the items that would be needed to address the levels of H2S that they're expected to be seen here?
Yes, they do.
And H2S, addressing H2S in a well can increase the cost, right?
I'm sorry, will you say that again?
Sure. The requirements that are needed to address H2S downhole can increase the cost, right?
Yes, it can.
And it's your testimony that those costs are already reflected in these AFEs,
Yes.
assuming you're using 110 casing.
That's what we use, yes, for the Avalon. It's also what other operators are using in the area.
And do you know if that's what Permian Resource is using?
I don't believe I know where their nearest Avalon well is. It's nowhere near Spicy Chicken, as far as I'm aware.
Regarding the Grayling wells, Avant did drill those wells, correct?
The 600s, we were turning over drilling at that time. I think our field staff was still on the rig, but we were not in control of drilling that anymore.
Were you still the operator of those wells when they were being drilled?
I think of record, yes, because we hadn't fully closed, but they had taken over operations before the closing date.
Back to the H2S for a minute. You mentioned earlier the XTO Anakin well that was plugged, right?
Correct.
And that was plugged due to issues involving H2S?
From my understanding, yes.
And that well used P110 casing, didn't it?
I believe so, yes. But I don't believe the issue was with the casing, as far as I'm aware.
Let's look at your rebuttal exhibits C1 through C3. And we can go through each of these, C1, C2, and C3. But you're relying on Avant's Cutbow development as your analog, correct?
That's correct.
And Cutbow is 2 miles to the north, right?
Yes,
And Permian Resources Paxi development is immediately adjacent to the Spicy Chicken development, right?
that's correct.
And on rebuttal exhibit C1, you compare Cutbow to Matador's Gavilan and Silver developments, right?
Yeah,
And those developments are about 4 miles away, aren't they?
yeah, it looks like that.
And they're located to the east.
Yes,
Doesn't the rock change as you go to the east from Spicy Chicken?
yeah, the rock changes as soon as you leave Spicy Chicken.
And you're showing here total cumulative oil production, right?
That's correct.
And Cutbow would have more production than those other units because it includes more wells, right?
Yeah, that's the point.
Okay, so this is not analyzing economics, correct?
No, no.
Let's look at your rebuttal exhibit C2. And there, the graph on the right shows about a 13% difference between the undepleted and the depleted well. Is that right?
I think it was. I think I got pretty close to that. Yeah,
Okay. And you state that that is not material degradation, right?
that's correct.
And then looking down at your first bullet point, you state that Permian Resources does not provide an analog to support its 48% degradation determination, correct?
Correct.
And have you reviewed Permian Resources Exhibit C11? In fact, I think you commented on it earlier when Ms. Bennett was questioning you.
That's correct. I did.
And Permian Resources uses the adjacent Paxi wells as an analog, doesn't it?
Yeah, I see that. I think this point would need to be amended. I'm not sure why I put that, to be completely honest.
Okay. And let's look at your rebuttal exhibit C3. And here you're comparing Avant's Cutbow development to Matador's Dagger State unit and Anderson unit, correct?
That's correct.
Okay. And is it correct that your point that you're trying to make here is that Avant's density in the first and second Bone Spring is preferable?
I am.
Dagger State and Anderson are roughly 12 miles away, right?
That's correct.
And at Dagger State, Matador drilled the wells in 4 phases between April 2017 and October 2022, correct?
I believe that's correct. Yes.
At Dagger State, the first Bone Spring and first Bone Shale wells are child wells to the second Bone Sand wells. Isn't that true?
Yeah, same situation at Spicy Chicken.
And earlier when you were testifying, you mentioned the Permian Resources Batman, Riddler, and Robin developments. Do you recall that?
Yes.
Okay, and those are not included in any of your exhibits, are they?
In this exhibit, no.
They're not included in any of your reservoir engineering slides, are they?
No, they're not. They were in Permians.
Right,
Yeah.
okay. And you said earlier that if midstream services became unavailable, it's a possibility to truck oil. Is that correct?
Yep.
Trucking oil would add significant costs to development, wouldn't it?
Yep. It's just a backup plan. Unlikely to happen in the area.
Those are all of my questions right now. Thank you.
Thank you.
Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Kelly, if Avant were to be the operator in these proposed units, and they drill out the Bone Spring 1 sand and Bone Spring 2 sand, would those completions interfere with Avant drilling and completing and producing infill wells in the Bone Spring 2 shell?
It hasn't been done very often. I know Matt or like Dana just stated down in the Dagger did it. And they did look to be slightly depleted, but not that bad. And this is also, like she said, 12 miles away. The rock does look a little bit different. We have quite a bit of height between our first bone target. I think it was around 350 feet between what we would target in the second shale. So I do think there is a good opportunity to come in and infill. But like I said, it just has not been done in this area, especially not on the infill basis.
If additional drilling and completing were to be done that would demonstrate that the Bone Spring 2 shell is productive, do you believe that Avant would attempt to complete wells in the Bone Spring 2 carbonate?
Yeah, 100% if the data is there. Of course, depending on price environment right now, it's obviously taking a turn for the better for us. So like I said, we've kind of been thinking about if we need to add it here at this oil price. So definitely with more data around the area, we would start to include if it showed that it was economic formation to produce. But that's still yet to be seen in this area.
Is that even taken into account if the Bone Spring 1 sand and Bone Spring 2 sand had been producing for a number of years?
Yeah, that is taking that into account. Like I said, there is quite a height difference between the three targets that we're drilling. There is some old second bone producers down in the north half of 26 that PR's plan is going to have to deal with already. So that's kind of already factored into the analysis, in our opinion.
But with the Bone Spring 2 sand wells in the north half of section 26 comparable to what Avant would be drilling in these proposed units?
It's comparable to our 1 mile laterals in the second Bone Spring sand. The shale would obviously come in above quite a bit. I can't remember the footage off the top of my head. I think it is around the 250 to 300 range above. So no, we are drilling the second bone sand in the same target that the wells in the north half of 26 were drilled in.
But are the completions within Avant's proposed wells comparable to the completions of those Katera wells?
Oh, I'm sorry. I misunderstood. No. Those wells were 2012 through 2014. They were old gel fracs. You're going to deal with a lot wider bi-wing fractures, not a lot of complexity like we see now with our, our high density slick water fracs. So yeah, different frac designs.
So would it be fair to say that Avant's wells in the Bone Spring 2 sand will have a higher accumulated volume than the Katera wells in the north half of section 26?
Yes, that is fair to say.
Within your direct testimony, not your rebuttal, do you include a summary of the costs associated with Avant's developmental plan?
In one slide, no, we have the dated AFEs like we discussed, and we'll try to get the updated AFEs over to council this afternoon, but there's not a slide in my direct testimony with all of that broken out.
We'll talk about it more tomorrow, but just an initial question. Approximately how much was the cost reduced in your rebuttal slide versus your original AFE costs?
I didn't look at the exact number. I think it was roughly $1 million a well to account for the extra. A lot of it was the extra cost we were putting on the steel, the casing, the facility, that we just haven't seen. And then we went ahead and ordered a lot of casing at a very good pricing environment for us. So a lot of that is just coming from straight supply chain issues. So hopefully we can see that when I get the AFE for you guys.
Thank you, Mr. Kelly. Thank you, Mr. Hearing Examiner. I have no further questions.
Ms. Bennett?
Thank you. I have one redirect.
Okay.
Mr. Kelly, do you recall when Ms. Hardy asked you if Avant would have to come back in to pool the second Bone Spring Shale?
Yes.
And do you know if Coterra would have to come back in and pool the second Bone Spring Shale, or if it could drill infill wells now?
I mean, they could drill an east to west well on top of their old second bones right now. As far as I understand it, they have 100% working interest. There's an old facility, old pad that you could expand and drill a U-turn east to west if they so chose. So,
Thank you. That's all. Thank you very much.
Anything further?
No, thank you.
Thank you. You may be excused. Okay, do you rest your case?
Yes.
Okay. Ms. Hardy, Ms. McLean, who's going to be presenting the case in chief? Ms. McLean.
I will. Is there room to take like a short bathroom break
Of course.
before we begin? Thank you.
5 minutes?
Yes,
It's
thank you.
2:41. We'll come back on the record at 2:46. Well, I'm having some difficulty myself. Where is Miss Bennett? Right outside the door. Would you grab Miss Bennett so we can start? Thanks, Freya. All right, it is 2:46. We're back on the record. Before you begin your case in chief, I just thought we'd hit a few high points here. I'm thinking about calling this at 4:30. It's obviously we're not going to get through all of your witnesses in the next, well, by 5 o'clock. Do you disagree with that?
I do not
You do
disagree.
not? Okay. All right. So we'll break at 4:30 for the evening. Is there anything that you want to discuss? Because when we break, we're gonna stop. So if there's anything you want to discuss now for tomorrow that you want to bring up?
The start time, I think you mentioned.
Yeah, that's a great place to start. What time are you available? I know you take your kids to school.
Yes,
So what time can you be here?
by 8:15,
8:15.
if that works. I know that Miss Bennett though has to
Commutes.
come from Albuquerque.
Yeah, exactly. Oh, you poor thing. You have to come all the way from Albuquerque.
No, I'm spending the night here tonight.
Oh, good.
Yeah, all like fancy pants.
Oh, good.
Yeah,
That's good to
Yeah.
hear.
but.
All right. So 8:15, I'm not hearing anything wrong with 8:15. So, right? Okay, good. So we'll start at 8:15 tomorrow. But is there anything, I know you're going to get some AFEs, some detailed AFEs to counsel for Permian for their review for some cross-examination and direct tomorrow. Is there anything you want to talk about?
No.
No. Okay. All right. Then I don't have anything else to say, so let's make the most of the next.
I do have one
ahead.
question for you. The Coterra case that's being called tomorrow morning.
Oh, yes. So why don't we call, we call it 8:15.
Okay.
We'll start the day at 8:15
Okay.
with it. I can't imagine it will be very long.
No, I hope not.
Well, I hope not too. All right. So go right ahead.
Thank you. Permian Resources calls its first witness, Mark Haddock.
Mr. Haddock, I remind you that you're under oath, and if you'll just press that green button, away we go.
Thank you. And can you please state and spell your name for the record?
Mark Haddock, M-A-R-K, H-A-J-D-I-K.
And by whom are you employed and in what capacity?
Senior staff layman with Permian Resources.
You're looking at her.
Okay. Layman with Permian Resources.
And have you provided direct testimony and exhibits in this case?
Yes.
And are those documents been marked as Exhibit A and so exhibits A1 through A12?
Yes.
And are they true and correct?
To the best of my knowledge, yes.
And do you adopt your testimony here today?
Yes.
Let's briefly discuss some of your exhibits. Let's go to your exhibit A6.
You said 6?
A6, yes. And what exactly is shown on exhibit? Oops, we gotta share. And what is shown on exhibit A6?
The spacing units or applications and the lease diagrams.
And let's go to page 2 of A6. Can you tell me what is shown here?
It's a working interest breakdown by tract and then a full unit capitulation.
And what tracks is Permian Resources seeking to pool?
We're seeking to pull all of the Bone Spring Formation and the Wolfcamp Formation in sections, in all of section 23 and the north half of section 26.
And is there any, are there any differences between what Permian Resources seeks to pull and what Avant seeks to pull?
Yes, Avant excludes the second Bone Spring portion, I guess in section 23, and all of the second bone in section 23, sorry, 26.
The north half of section 20.
Yes, the north half of section 26.
Let's look at your exhibit A5. Can you tell me what this shows?
It's a diagram showing the second bone, how Avant is excluding the second Bone Spring from their development, and how it will strand the north half of section 26.
And why does this strand the second Bone Spring in the north half of section 26?
The BLM revised the drill islands and development areas in light of this, of the Spicy Chicken development area getting granted, and canceled the drill island that the Snotty wells came from in the I believe northeast corner of the north half of section 26. So we ran to ground the option of self-development of section 26, and that was deemed no longer viable by the BLM.
So Permian Resources looked at self-developing the north half of section 26 and the BLM said no.
Correct.
And why is self-development not possible?
Due to the potash restrictions and the lack of drill islands, you're required to come from the north of section 23.
So if Avant wins operatorship in these competing developments, what would happen to the second Bone Spring in the north half of section 26?
According to their applications, it would stay stranded.
And could Avant drill wells in the second Bone Spring in the north half of section 26?
Not currently.
And why not?
They don't own anything. They don't own any working interest.
In the north half of section 26?
Correct.
Let's look at your exhibit A10. What does this exhibit A10 show?
So project development and communication timeline, where we've been working on resolving disputes and BLM potash issues starting back in 2023 when we acquired it, and our predecessor Earthstone had been working on it prior to this. In addition to some communication with other parties throughout here.
And let's go to exhibit A12. And this is your communication timeline with Permian Resources and Avant, correct?
Correct.
And have you had extensive communications with Avant?
Yes.
And have you reviewed Avant's communication summary?
Yes.
And do you believe Permian Resources and Avant's communication summaries are accurate?
Yes, but for whatever they plan to edit.
And why do you think that what they plan to add is?
Well, it's not inaccurate. I just don't know what they're going to add.
Oh,
And so
yes.
it won't be 100% aligned.
And do your exhibit A12 and Avant's exhibit A6 show that negotiations have been extensive and ongoing between the parties?
Yes.
What's your understanding of Avant's position in these cases?
That they should be granted operatorship solely on a larger working interest. Should be granted operatorship solely on the larger working interest.
And do you agree with that?
I do not.
And have you provided a rebuttal exhibit, which has been marked as exhibit A13?
Yes.
And I know this one has been objected to, so we'll try and use it at this point.
Hold on, let me just verify that. Let me think for a moment. I thought C13 and C14 were admitted. Oh, not A.
A13.
These are As. Why don't we
Yes.
deal with all the As at the same time? why don't you try to get them in? Let's find out first what the objection is. We have all of your direct exhibits have been admitted. No rebuttal exhibits except for C13 and C14. So this witness here created which rebuttal exhibits?
There, it's just A13. He only has one.
A rebuttal exhibit?
Yes,
Okay,
correct.
A13. Hold on a second. Let me mark this down. A13. Miss Bennett, what is the objection to A13?
Thank you, Mr. Hearing Examiner. A13 is simply a compilation of what's already in the record. It's a comparison, a side-by-side comparison of Avant's chart of working interest ownership and Permian's. And so it adds nothing to the record, and they already used it as a demonstrative for that purpose. In addition to that, the calculations that they are showing on Exhibit A13 are irrelevant because they compare Avant's actual working interest ownership with the theoretical hypothetical working interest if all of the overrides convert. And so the substance is, there's one tiny little bit of substance that's new and it is irrelevant.
So I'm just trying to make sure I understand. Number one, we have redundancy.
Yes.
Right, okay, so we have redundancy, but that wouldn't stop it from being used as a demonstrable, right? Number two, there was an issue about the actual data that is portrayed in the exhibit, and you lost me. You said, repeat what you said about what they're showing and how it's not correct.
Sure. And Ms. McLean, would you be able to turn to that exhibit? Thank you.
And
So-
make it a little bigger, hit the plus just a couple times. Yeah, that's perfect. I can see it. Go ahead, Ms. Bennett.
Okay, so again, the two tables, the two primary tables are just recapitulation of what's already in the record. And then the variance is what I'm referring to now. So the variance is showing a difference in Avant's calculated acreage and Earthstone's calculated acreage. And number one, that's simple math. I don't think we need a rebuttal exhibit to have simple math in the record. But number two, it's based only on and it says here on the unaccounted for conversion of overrides. And the conversion of overrides has not happened. So this is a speculative comparison comparing Avant's actual record title against the speculative conversion that Permian is advancing in its case.
Okay, and your response?
Yes, well, I don't know about simple math because I went to law school because I was told there would be no math. But I think that this is particularly relevant and helpful, especially in light of the questions that Mr. McClure asked their land witness earlier today to describe the differences in the calculations and the differences between the two working interest calculations between the parties. Furthermore, one of the cruxes of this entire case is, should we be calculating these overrides? Avant says no, we say yes, it is of record. It's an option that everyone has, and we believe that it's necessary. So we have an accurate portrayal of, what that working interest might be. And Permian Resources believes that they are pooling all potential working interest owners. So we do not have to waste the division's time and come back and reopen the cases to pull additional people should they convert their override into working interest. So we believe that this is relevant and, crucial to understanding the differences between the parties.
Okay, let me ask Mr. McClure a question. Mr. McClure, I think I know which way I want to go with this objection, but do you find this slide helpful? And if so, just let me know that you do or don't.
I mean, I don't think it hurts to have it.
Well, that wasn't the question that I asked, but if that's the answer you want to give me, I guess I'll have to be stuck with it. Ms. Bennett, when it comes to the redundancy factor, I can understand the objection. However, I think having everything, as long as it's accurate and you have the ability to cross-examine this witness to show any inaccuracies in this table, okay? But I find that the table is helpful in gathering information that might be all over the different exhibits and bringing it into one exhibit. So for that reason, I'm not supporting the redundancy argument. For the idea that it's comparing apples and oranges, basically that's what you're saying here. You're saying that here in this bottom left table, the variance summary, Permian is showing Avant's current, or I thought Avant actually was a little bit more than 90% anyway, wasn't it?
Yes, I think that what they're showing in the variance there is the difference between what Avant attributes to its working interest ownership based on title
Right.
and what Permian attributes to its interest based on this hypothetical conversion.
Right.
And then taking the two and subtracting them. So the 90% is not Avant's interest, it's the delta between what Avant shows and what Permian shows.
Gee, I didn't even understand that.
I think that
But
makes
we
my
haven't
point,
had any
but-
testimony on it yet. I didn't even understand that. Would you explain that one more time? Because I still don't understand it.
Sure, and I'm happy to explain Mr. Hadjick's testimony, but so
What are
what,
they showing here? What's this numbers here, the 90
Okay.
and the 41?
that's the difference between, that's taking Avant's total acreage that Avant showed that it had on its slides and subtracting from that the acreage that Permian credits to Avant to say that Avant is inflating its acreage by 90 net
This-
mineral
This
acres.
isn't working interest. This is
Yeah,
acreage.
It's
only.
acreage only.
I didn't understand that.
Mhm.
Thank you. I appreciate that. And I didn't know that. I'm going to allow this exhibit in. So this exhibit comes in and you can cross-examine and show us how it's not reliable or inaccurate any way you like. But for me, I appreciate the fact that someone compiled all of this data. So I find it relevant. I just don't know how accurate it is, but we'll find out.
Thank you. All right.
So did you catch that, Ms. Schoenberg? You did. So this exhibit comes in, and this exhibit is what number?
This is
A13?
exhibit A13,
A13, okay?
Permian's exhibit A13.
Rebuttal.
Rebuttal. Yeah,
No, you just have it listed.
we just have it in sequential order.
So go right ahead.
So this has been admitted.
Yes, it has been
Okay,
admitted.
thank you. All right, can you tell me what, in your words, is on exhibit A13?
A13 is the tables extracted from the original testimony that Avant rolls up, does not take into account any conversions in their table. And then it compares it to the potential for the parties to convert on our table. And then this table also shows the parties that were left off of Avant's pooling applications that have the opportunity to be working interest partners here.
And the parties that were left off of Avant's working interest table, those are in red?
Correct.
And can you tell me which parties those are?
Citadel Energy and Blue Star Royalty.
And then in looking at the comparison between these two working interest calculations, these are only the working interest ownership tables for the 1.5 mile first and third Bone Spring wells
Correct. Well, and Wolfcamp.
in Wolfcamp, because all of that ownership interest is the same, correct?
Yes, it's contiguous.
And it's the second Bone Spring that has the different ownership.
Correct.
And is there a big disparity between what Permian Resources is showing as ownership percentages and what Avant has?
Correct. If parties were to convert, then Avant's working interest is inflated by 90 acres.
And why is that? Why would their ownership interest be inflated without that conversion?
Can you restate the question?
Why is there a disparity between what Permian Resources is showing and what Avant is showing?
I mean, in my opinion, it's advantageous for them to show the unconverted table because it makes their numbers look better.
And Permian Resources table takes into account the ability of all parties that can convert to working interest percentages, correct?
Correct.
And Avance does not.
Correct.
And why does Permian Resources take that conversion into account when making its calculation?
It's a unique scenario. So we thought it was the best approach to utilize the ownership that could be the maximum potential working interest parties who are of record, because their right to convert is of record as of the filing of this case.
And have you reviewed Avance rebuttal exhibits?
Yes.
I'd like to draw your attention to Avance rebuttal exhibit A2. And can you tell me what this is?
This is the document of record that that gives these parties the right to convert their override to a working interest at the time of drilling subsequent wells.
And can you tell me what exactly this says? And I think Avant calls it out in their exhibit about the ability to convert an overriding royalty interest to a working interest.
The parties that are subject to this document have the option of converting their override interest. I think you scroll down. Sorry, I can't see it.
Right here. Oh, no, it's just up there. There you go.
And then such option, like, sorry, what was the question? I lost the train of thought when you were on.
Oh, just
Sorry.
if you could tell me what exactly this document says about the ability to convert an overriding royalty interest to a working interest.
These parties have the right to convert, and then they have to be given notice, and they have set amount of time to provide response to said notice.
And just to clarify, not every overriding royalty interest owner that's listed on Permian Resources or Avance overrides that are going to be pulled in this case have this option.
Correct. There are overriding on royalty owners that are just a straight override owner. This is a select few that are subject to this agreement.
And if someone did convert from an overriding royalty interest to a working interest and you didn't list them as a pooled working interest owner in this case, what would you have to do?
Barring voluntary agreement, you'd have to come back to the commission.
To pool them?
Yeah, you'd have to reopen the pooling cases. You would have to reopen the pooling cases.
And do you have experience with people actually electing to convert from overriding royalty to working interest?
Yes, several parties in here, while we think it's premature, did file a notice of intent to convert.
And is Permian Resources planning on converting its overriding royalty interest to a working interest?
Yes, once given, yes, we intend to convert our override to a working interest.
So would you call it hypothetical that someone can do this or realistic?
Realistic.
When would you anticipate parties to actually make this election in your experience?
Well, there would have to be an operator named, and then it would be pretty imminent to the actual spud of the well. And then at that point, you would get it based on the verbiage we see here. You'd be then given an election and the opportunity to convert.
And is Permian Resources' ability to convert its overriding royalty interest to working interest ownership reflected in any of Avant's ownership interest breakdowns?
Not in their initial ones, from what I can recall.
And why do you think Avant calculated the ownership interest in this way?
As we saw in my rebuttal slide, it advantageously inflated their working interest.
And do you believe Permian Resources calculation to be more realistic?
Yes.
In your opinion, will Permian Resources Development Plan best prevent waste and protect correlative rights?
Yes.
And would Avant's plan result in waste and violate Permian Resources and others like Coterra's correlative rights?
Yes.
Can you please summarize the reasons for that?
Permian Resources has been working diligently to develop our significant interests in a way that does not strand acreage and provides the best protection for elder rights and value for the owners.
Thank you. I have no further questions.
Ms. Bennett?
Thank you. Good afternoon, Mr. Haddock.
Definitely.
Silent J.
Yep.
Thanks for being here. So I wanted to just start off with your declaration and your exhibits. They're meant to be accurate to the best of your knowledge, right?
Yes.
And they're meant to be complete to the best of your knowledge.
Correct.
And did you prepare your exhibits?
Yes.
And are they all based on your personal knowledge?
To the best of my knowledge, yes.
So you acknowledge, right, that the numbers you included in your ownership breakdown are based on the assumption that the overrides will convert.
Under the maximum case, yes, that's what my tables accounts for.
And just give me a second here. I'm gonna start sharing. Sure why I can't share again. Okay. So this is your self-affirmed statement, Exhibit A, right?
Yes.
And I want to look at your exhibit on page 130 of 278, which is your working interest summary. It's part of Exhibit A6. Are you seeing that?
Yes, I can.
And this is your working interest summary for section 23 and the north half of section 26. Is that right?
Yes.
And at the bottom in this asterisk here, it says, and tell me if I'm not reading this correctly, the table above assumes the parties have elected to participate in the development with the working interest. Did I read that correctly?
Yes, because it's the most complete way to look at the ownership of record.
And it's based on an assumption though, in your own words.
It is.
Okay, thanks.
What
You testified a moment ago that you thought this was the best approach with respect to Citadel and Blue Star as overrides that have not yet converted. Is that right?
correct, because they could be working interest parties.
Have you had conversations with Citadel about it becoming a working interest party?
I have talked to most of the parties here.
Does your communication record reflect a conversation with Citadel?
I would have to go back and look. There was a lot of conversations, and
So you don't recall a conversation with Citadel, even though it's in your testimony?
yes, if it's in there, then yes, I did talk to them.
But do you recall what they said to you about converting their working interest?
I don't recall if we discussed conversion.
Okay, give me just a second here and I'll get to your summary of context. Do you see where I'm looking here on March 31st to April 7th, 2026?
Yes,
Is this a summary of your communication with Citadel?
yes.
And could you read it for the division, please?
Email exchange with Citadel regarding their preference to sign a JOA or support letter.
Regarding their preference.
To sign a JOA or support letter. Citadel elects to remain neutral due to marketing their assets to give the buyer the optionality to convert at their discretion.
So Siddle did not want to convert at the time that you communicated with them, did they?
There's no conversion until there's an operator with a well.
Did Siddle indicate that it was open to converting at the time you communicated with them?
I don't think I don't understand your question.
Your email exchange says that Siddle elected to remain neutral. Did you write that to mean that they elected to remain neutral in terms of converting their override?
I wrote that to mean they still have the optionality to convert their override.
Have they converted their override?
I think I said, answered that question a minute ago, that there's no operator and no election given yet.
Is that why Permian hasn't elected to convert its working interest, its override into a working interest?
If we were named operator, we wouldn't need to, I mean,
So isn't Permian using the assumption in your slides to show the working interest ownership in a light most advantageous to Permian?
showing it in a light that captures the maximum number of potential working interest parties here.
Do you think that, so is it, in your discussions with Siddle, did you let Siddle know that you were going to be pooling their override and their working interest in this case?
They received notice of the well proposals.
So you're pooling a, as of yet unelected working interest, right?
They are a party of record that could have a working interest, so they were entitled to notice of the hearing and a well proposal.
Have you, so Permian has had this opportunity to convert its working interests, I'm sorry, its override to a working interest since Earthstone acquired this acreage? Is that, or Earthstone had the opportunity? Is that accurate?
There was no subsequent wells to currently.
Didn't Earthstone propose wells in 2023?
Pre-pooling proposals are not binding.
Didn't Permian file a pooling application with the Earthstone file a pooling application with the division in 2025, 2023, 2024? I don't have the exact dates.
Yes, we did.
And did you elect to convert your override? Well, you didn't elect to convert your override before those pooling cases, did you?
There was no post order proposal sent.
So the answer is no.
There's no subsequent wells to send an election on.
Okay. I wanted to take a look at your exhibit. Go back to your exhibit A6. This exhibit does not compare and contrast Permian's ownership to Avant's ownership, does it?
That's a standard unit capitulation.
And even under your assumption, Permian has 40% owned and controlled.
Right.
And that's not the majority interest, is it?
No, but we have a material interest here to protect.
And so does Avant, right? Let's see. Oh, I wanted to turn to your next slide. This is your recap for the section 23 ownership. Do you see that?
Yes.
And could you walk the division through how you came to Permian owned and controlled 18.116%?
I think we've already addressed that in the we use the numbers of maximum potential parties that can convert.
And I'm sorry, I'm trying to be a little more granular than that. I actually want to know how you added up the parties that are actually signed up with Permian to come up with the 18%. So that's WR non-op, right? Is WR non-op under a contract to acquire?
Yes, there's possibly an error here. I don't have a calculator,
But you think that the 18% could be inaccurate?
yes, because yes, there's probably a typo there.
And so it should be lower than 18, is that what you're saying?
Yes,
And on this is again, the unit recap for just the 640 acre section 23 tract, right?
correct.
And yet for the first entry, Earthstone Permian, it says that you have acreage in tracts 1 and 2. Is that a typo as well?
Yes, this is only tract 1.
I want to look at Avant's rebuttal exhibit. A1. Sorry, there's a faster way I could do this, but it's not happening at the moment. Okay, turning to A1, this is the assignment and assignment of overriding royalty interest and options. Do you see that? Why didn't you include this in your materials if you were relying on it to support your assumption of working interest ownership?
It wasn't initially included in yours either. I'm not following the question.
Well, Avant did not need to include it initially because they're not basing their calculations on an assumption, whereas Permian Resources.
Objection. This is testimony by counsel at this point.
Okay, sustained. Would you answer the question she asked you though? Because she asked you a question and you said, well, it's not in Permian's, sorry, it's not in Avance either, but that's not an answer to the question. So would you ask the question
Yes.
again?
Yes, I will. So why did you not include rebuttal exhibit A1, which is the assignment of overriding royalty interest and options upon which you base your calculations in your exhibits?
Title documents are not typically necessary for standard pooling exhibits.
What?
Title documents are typically not included as standard pooling exhibits.
A moment ago, you testified, though, that this is an unusual circumstance. And so wouldn't this be outside of the normal pooling application when you're relying on an assumption of working interest ownership to support that assumption?
I don't think there's a dispute that this exists, so I'm not sure what the necessity what's the question?
Well, but you do have to answer the question. So instead
Sorry,
of
what's the-
debating the necessity of the question, just answer it, please.
I meant of the document. I didn't mean, what's the question? Sorry.
The question is, a moment ago, you testified that this is an unusual circumstance. And also that this type of exhibit is not normally submitted in a usual pooling case. But here where Permian is basing its affirmative case on an assumption related to a document, I'm asking why Permian did not include that document in its original materials.
I didn't think it was necessary. I thought the tables spoke for themselves.
Now, you testified a moment ago that the assignment of overriding royalty interest and option agreement is of record. And I don't think anyone's disputing that. What my question is whether, for example, the working interest that you've attributed to Siddle, for example, is that of record, that they own a working interest at this moment?
They have the opportunity to own a working interest according to this document.
And that's all they have, right, is the opportunity?
Well, yes, they own, I mean, yes.
Thank you. I want to now look at Avant rebuttal exhibit. A3, are you seeing that?
Yes.
And understanding that, well, have you had a chance to review this exhibit?
Yes.
And do you have, in your opinion, does this exhibit reflect the interest that will accrue if the hypothetical conversion takes place? of all overrides to working interest?
I believe so. I don't check the actual calculations, but
Sitting here right now, do you have any reason to doubt the interests that are reflected here as post-conversion interests?
no.
And this rebuttal exhibit A3 shows Avant with 85.54% working interest control, does it not?
As to a limited number of the wells.
This is all of the wells in section 23, the 640 acre spacing unit, isn't it?
But not all, but that's a limited number of the wells.
I understand it's a limited number of the wells. I'm asking you about the wells in section 23.
Limited to the wells in section 23. This would be the table.
And both Permian and Avant are proposing wells in section 23 only, right?
Yes.
And then turning to exhibit A4. Are you seeing exhibit A4?
Yes.
And again, this is Avant's calculation, assuming, taking into account your assumption that all of the overrides that have the opportunity to do convert to a working interest. Do you see that?
Yes.
And do you have any reason to doubt that these numbers reflect a total conversion?
No.
And at the bottom, you see where Avant calculated its working interest control as 57.86%. Do you see that?
I do.
So Avant, under either scenarios, your scenario or Avant's scenario, has the majority working interest in the 1.5 mile laterals.
I don't think there's a dispute to that. I think there's
Okay.
more to the
Thank you.
case in protecting correlative rights.
Thanks. Then I wanted to you're aware that Avant operates a vertical well in section 23 already, right?
I believe they purchased one. I have not confirmed it myself, but sure. I'll take your word for it.
Okay. Then turning back to your rebuttal exhibit, let me see if I can get that. It doesn't seem quite right to me. So originally I thought that what you had done was just taken Avant's working interest ownership table and compared it to your working interest ownership table. But it doesn't look like that's what you did actually. Is table 1 something you created?
It was pulled, I manually created it off of y'all's exhibit. Avant's exhibit.
Okay, and so it shows. So it shows Avant as having 80.28%, which I know you dispute. I'm in the table 1. Are you tracking with me?
Yes.
And then cheap capital. And then it shows WR non-op, force pool, trainer, force pool. And those were the interests that Avant was seeking to force pool, right?
At the time.
And so you now know that trainer though is being acquired by Avant.
Based on your rebuttal exhibits, yes.
And so this calculation that you've put in here, it no longer reflects the on the ground status of discussions with Avant. With trainers discussions with Avant.
I wasn't privy to those. I mean, this was accurate at the time I made it.
And then on your exhibit, the table that you created, I see Siddle and Blue Star as identified in red italics. And those are the potential working interest owners that Avant did not pool as working interest owners. Is that right?
Yes.
But that Permian prematurely pooled as working interest owners.
Comprehensively pulled them.
Then I wanted to I wanted to talk a little bit about Petrolux. So you have identified here that Petrolux was conveyed to a predecessor of Earthstone. Do you see that?
Yes.
And were you here earlier today when Ms. Sarantino's testified that Petrolux actually, this interest was not conveyed to Earthstone according to Avant's title review?
Our title opinion has it credited to us.
And so, but there can be differences in title opinions. Is that a fair statement?
Yes.
And then I think that's it on those. Okay, I wanted to next talk about your Wolfcamp 201H application. So let me just get there. And that is, sorry, I'm not sure which application number that is. Okay, this is it, 25835. Are you seeing that?
Yes.
Are you familiar with your Wolfcamp 201H application?
Yes.
Did you help prepare the Wolfcamp 201H application?
Yes.
So the 201H application here says that it is a 400 acre, more or less, standard horizontal spacing unit. Do you see that?
Yes.
And do you see in paragraph 2 where it says that it's going to start in unit D of section 23 to a last take point in unit C of section 26?
Yes.
Does that accurately reflect your exhibits?
I believe there was a typo in, regarding unit C.
So your exhibits do not reflect what's in your application. Right?
Correct, according to this.
Well, do you have any reason to doubt that this is the application you filed?
No, I'm sorry, correct.
Yeah, just to confirm, this is your testimony. And this is your exhibit A. And you say in the case 25835, which we just established was the 201H case that Permian is seeking to pool uncommitted interest in a 480 acre spacing unit. Is that different than your application?
Yes, I said there was an error in the application, I believe.
And then I wanted to look at the C102 for the 201H well. See if I can find that. Do you think there's an error in the C102 as well?
That was a question.
Yes, that is a question. I'm sorry, I didn't have a chance to look at you. I was looking at for the C102.
I don't. Yes, on your highlighted part right there, there's an error.
And so what I've highlighted here shows that the C102 is purporting to say that the 201H well is going to be dedicated to a 400 acre unit.
It should be 480.
And do you see here how it shows the first take point is in unit D and the last take point is in unit E?
Yes.
And do you see here on the drawing that the first take point is in D and the last take point is in E?
Yes.
Would that be a 400 acre unit?
No, I said it would be 480.
So is this estimated acreage on here added after the fact?
I don't do those.
You don't prepare the C102s?
No, I'm not a surveyor.
Did you review it though before? It's part of your exhibits, right?
I review them as best I can. I don't.
But you'd agree with me that this C102 does not the dedicated acreage on this C102 does not accurately reflect the drawing on the C102.
Correct. I already stated that the 400 is incorrect.
I noticed in your applications and you're actually on your C102s that you've identified the Wolfcamp wells as being in the Osuto Wolfcamp South gas pool. Do you see that on the C102?
Yes.
Is it your understanding that the Wolfcamp wells are in the gas pool?
I believe so.
When was that? When did you start to have that understanding?
I'm not sure.
Was it before you submitted your applications or after you submitted your applications?
It's been a long time since these applications were filed. I don't recall.
Are you aware that your Wolf Camp applications are spaced off of oil spacing and not gas spacing?
Yes, we plan to file for administrative cells
For administrative NSLs?
or NSP, sorry.
But you will have to file. So I saw that in your applications that you said that now you think these are non-standard units when before you thought they were standard. And now you think they're at one, that they're, you'll need to file an administrative application for non-standard unit. That's in your testimony, right?
Yes,
Do you know what the setbacks are for a gas pool for the first and last take point and from the laterals?
I'm not familiar with each pool, but I think generally 330.
So will you have to file for administrative approval for NSLs as well? Are your first, shall I show you a C-102? That'd be
I
helpful.
think I just said we would put. Sorry, ask your question again.
Sure. So I understood from your testimony that you plan on filing administrative applications for non-standard units. But what I'm asking you now is if you'll need to also file administrative applications for non-standard locations, given that your wells are spaced
I
off.
think I meant non-standard location, not NSP.
Okay, well, your testimony says non-standard unit, but that's neither here nor there. But you acknowledge that there's further steps that you have to take, whether it's correct in your testimony or not correct in your written testimony.
What am I correcting? What was the question?
I'm saying, my question is, you acknowledge that there are further steps that you'll have to take with the Wolf Camp applications as you understand them post this hearing.
Yes,
A minute ago, we talked about the fact that Avant owns or operates a well, the Bates 23 well in section 23. And you said you were generally aware of the existence of that well. Is that right?
yes,
Are you aware of the requirements for seeking approval of overlapping spacing units?
yes.
And is the Bates well within the section 23? Is it within the west half of section 23?
I don't know where it is.
In just a second, if you don't mind, I'm going to go ahead and pull up one of your geologist slides and I'll be able to show you where it is. It's in section 23. We can leave it at that for the moment. Do you know if either of your section 23 applications identified that well as a existing spacing unit?
I believe it was that well's dedicated to a different pool. To a different pool.
What pool do you believe that's dedicated to?
I don't know what pool it's dedicated to, but I didn't believe it was the ones that were doing the horizontals.
If it turns out that it is within the same pool or formation as your proposed west half or east half section 23 application, will you need to take additional steps to seek approval for an overlapping spacing unit?
If it's in the same pool, then yes, we'd have to.
And earlier, or you were here earlier today and I think your testimony even references the 3 snotty wells that are in the north half, well, in section 26. Do you recall those 3 wells?
Yes,
And actually, I think you have an exhibit I can use to show those wells. So this is a representation of those 3 snotty wells, right?
yes,
And the northernmost well traverses the entire north half of section 26, right?
yes,
And the slant well traverses the east half and the west half of section 26, right?
yes.
Do you know if you included those wells in your overlapping spacing unit approval requests in your applications?
I have an exhibit on. regarding the overlapping spacing unit.
So I understand you might have an exhibit for that, and I'm happy to get to it. I don't think it adds much to this discussion, but what I'm asking is do you know if your applications, all of your section 26, all of your applications that seek to pool section 26 in the Bone Spring, whether those applications identified the Snowdy wells as overlapping?
I don't recall.
Okay, and based on your knowledge of the overlapping spacing unit rule, would you need to do additional steps after this hearing to correct that oversight if it is in fact an oversight?
I'm not, those are matters typically handled by council. I don't know the exact procedures.
I understand that you may not know the exact procedures, but do you have a general understanding that there would be additional procedure?
Under your hypothetical, yes.
I wanted to look at your paragraph 6 of your declaration. Okay, do you see where I am on paragraph 6 of your declaration?
Yes,
And in paragraph 6, it's got a blanket statement that Avant is not seeking to pool or develop the second Bone Spring interval. Is that correct?
no, it references exhibit A5, which would further define that.
And I understand it, I'm sorry, it references A5, but is that statement in your declaration correct as written?
You're taking it out of context.
This shows Avant is drilling wells in section 23 in the second Bone Spring, right?
Correct.
You mentioned earlier that you'd had discussions with the BLM about the inability to use the existing drill pads and the, what would those be, the east half of section 26? Do you recall that testimony? Is anything about that, and did you provide any correspondence with BLM in your materials?
No,
Are you able to provide any correspondence with BLM to support your statement?
I can go back and look. I believe I have an email from Jim Rutley.
And you said something that I thought was kind of interesting. You said that you ran down the option of self-development of the north half of section 26. Is that what you said?
Correct.
And by self-development, you mean Permian developing it, or did you mean Coterra developing it?
Well, Permian developing it.
So how is that self-development?
We would be drilling our acreage that we own in section 26.
What acreage do you own in the north half of section 26 in the second Bone Spring Shale?
We don't own, it was
Thank you.
regarding all statements
Thanks.
or all wells.
And earlier, referencing the same exhibit, you mentioned, or you testified that Avant's plan would strand the north half of section 26. Do you recall that in the Bone Spring?
Yes,
And you were here earlier when Avant said it could actually go in and drill second shale wells, right?
yes.
And you testified earlier that you've been diligently pursuing your acreage position in sections 23 and 26. Do you recall that testimony?
Yes,
And yet you have not converted your overriding royalty interest to a working interest, which is in your own control. Is that right?
as we discussed earlier, that is premature at this point because there's no subsequent wells.
I understand that's your answer, but I'm asking you a question about whether you have done it yet or not. And you haven't done it yet, right?
There's nothing to convert for. There's no subsequent wells.
Earlier, you spoke about the difference between the Avant operating, or the Avant interest and the Permian interest, and you said that Permian has a significant interest. Does that sound about right to you?
Yes,
And even under your scenario, though, it's not a majority interest, is it?
it's a significant interest of 38 to 40 something percent, depending on what you say.
But it's not the majority, right?
No.
Earlier, you testified that the right to convert is of record when you were talking about the assignment of overrides and option. Do you recall that?
Yes,
And so it's your testimony that the right to convert being of record is the same as having converted being of record?
yes, because that right exists at all times.
Thank you. I think that might be it, but I just want to double check with my colleagues to make sure I didn't miss anything. Thank you. No further questions.
Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Haddock, I guess, jumping into the topic about this conversion of overrides into working interest. I don't pretend to be a contract lawyer by any stretch, and I assume you're not either.
That's
But
right.
what is your understanding as to when this conversion can take place?
When there's a named operator that is imminently about to drill subsequent wells,
Now, where are you getting that from, though?
the agreement that says the agreements uses Baskin as a reference, but it's, you imply that there would have to be an operator that's going to drill a well.
Avant's rebuttal exhibit, like A2 here, do you agree that this is an accurate representation of the contracts in place?
Somebody pull it up, please.
What is the exhibit number?
Mr.
Looks like-
McClure?
Looks like rebuttal exhibit A2 from
Okay,
Avant.
I can pull it up. Is this the exhibit?
Yes, Mr. McLean. Are you with us, Mr. Haddock?
Sorry, what was the question? I couldn't hear.
Are you with us?
Yes,
I mean, do you see the exhibit that Ms. McLean has pulled up? Is the better
Yes, I see
question,
it.
I guess.
yes, I see it.
Do you think that this is an accurate representation of the contracts in place?
I think it might be misleading at best because these parties have the option to do that, and this agreement probably did not take into account the horizontal force pooling world back in 1978.
Well, I guess let me ask the question again. Do you think, irregardless of whether the contract in place takes into account horizontal wells, is the snippet of a contract that we have on the screen right now, is that representative of the contracts that are in place currently?
Are we talking about the black part or the red part?
well, I guess it would be well, the black part that's on the left-hand side of the screen and has like a notary or something in the background on it. You see what I'm referring to? Not the red text that's a part of the exhibit, but like the text that's under assignment of overriding royalty interest and options. Do you see where I'm
Oh.
referring to?
Yeah, paragraph 2.
Well, the entirety of that, like it has like paragraph 1, 2, and 3. There, do you see the text that I'm referring to kind of on the left side of the screen?
Yes, sir.
Yeah, do you have any reason to believe that this is not representative of the contracts in place?
No, I don't think there's a dispute that the parties have the option to convert.
Yeah, but the verbiage, the language that's included here, you think this is accurate to the contracts that's in place, is that correct?
I mean, this is the contract, yes.
Okay. And do you agree like under option or paragraph 2 there, it discuss when the occurrence of a payout to the operator takes place for the first well? Do you see where I'm referring to?
Yeah, yes.
Okay, so I guess what would be your interpretation of when the conversion can take place?
I believe the reference to the payout was from the original well that was drilled in the 1970s and is no longer applicable here. Our position is that if you look at paragraph 3, is that subsequent wells, which is what these wells are, when they're commenced upon the premises, that such options shall be provided, or provided that such option, excuse me, I can't read. Provided that such option shall be exercised within 10 days of written notice.
Okay, so then it is your opinion that paragraph 2 has already taken place and that all the wells that's being considered today would fall under paragraph 3 then, is that correct?
Yes.
If that were to be the case, then hasn't the election letters that references the I guess quote unquote infill wells already been provided to all the interest owners?
But there's been no well commenced. Each subsequent well that is commenced on the premises. So to date, no subsequent wells have been commenced.
So it'd be your interpretation that the subsequent wells need to be drilled before it could be converted. Is that correct?
As I read that, yes.
Now you're making an assumption that, or let me backtrack. Is it accurate to say that you're assuming that all of the overriding royalty interest owners that have this option are going to take this option?
We found it was necessary to take that assumption so that there was an accurate picture of all parties that could potentially be working interest parties to the wells.
If that was your consideration, why did Premium not provide 2 different sets of numbers then? One for if the option was taken and one for if the option was not?
Because there's a number of parties, I mean, the hypotheticals could be endless under that kind of line of analysis.
Well, assuming that none of the options are elected to occur, do you agree with the interest breakout that Avant has referenced for these proposed units?
With the exception of the title dispute, yes, generally.
And by title dispute, can you elaborate on specifically what you're referring to by the title dispute?
The discussion of Petrolux that has come up. I think there's a gray area as to who owns that, but other than that issue, there's no dispute with the tables.
Again, who would you attribute Betrol, Lex, or the title that we're referring to? Who would you attribute that interest to?
Our title opinion has it attributed to Earthstone Permian, being Permian Resources.
Oh, I was trying to scroll up to the CPACs and was on the wrong exhibit packet. Mr. Haddock, if I can draw your attention to, I think it's on all the Bone Spring CPACs. You may already be familiar with the issue, but if I were to ask you what the API number is for the Hansen State number 1 and make the corrections across the entire exhibits packet, do you understand what I'm asking for?
There's an issue with the Hansen.
Yeah,
Yes.
Miss McLean, if we can bring it up just to make sure Mr. Haddock knows what I'm referring
Yes.
to.
It sounds like we just had the wrong API number on that.
Yeah, that's correct. Well, you're missing one of the digits, essentially. I think it has a 7 at the end of, if I remember right, but whatever it happens to be, if we can correct it to be a correct API number. It sounds like you're aware of what we're
Yes.
talking about, Miss McLean.
Yes, we can correct that. I'm aware.
Okay. And based off your earlier testimony under question by Miss Bennett, it sounds like, Mr. Haddock, that you're aware of the issue with the application for case number 25835 and the legal description. Is that correct?
Yes.
And you're aware that this pertains to all the notice, including the public notice that was conducted for this application?
I believe so.
For the first Bone Spring cases, what is the vertical limit that Permian Resources is asking the division to force pull?
I believe that's a geology question. If you're asking the TVDs.
I'm not asking for the TVDs. I'm asking for what in general formations or subset of the formation is Permian requesting the division to force pull.
I believe it was a top of the bone spring to the base of the first bone.
I'm sorry, could you say that one more time, Mr. Haddock?
I believe it was the top of the bone spring formation to the base of the first bone spring formation.
Can you please provide a brief description of where the depth severances occur within the Bone Spring Formation? In
Yes,
general, I don't need the TBD.
Yep. It's a tidal severance in the north half of section 26, where the second bone spring is owned by Coterra, above and below the top of the first, above and below the top of the second bone spring. The ownership is contiguous.
Okay, so then the depth severances occur at the top of the bone of the second bone spring and the base of the second bone spring, correct?
Yes, as to the north half of section 26.
Well, is it just for the north half of the section 26? Because the depth severance goes across section 23, does it not?
No, there's no depth. There's no title severance in section 23 as to the Bone Spring and Wolf Camp. Just section 26.
Well, I guess I was misunderstanding that part of it then. Okay, so then the entirety of the bone spring formation within section 23, it has identical interest.
Yes,
And it's only the north half of section 26 that has depth severance in it.
correct.
Is it correct that you now understand that the Wolf Camp cases would be for oil pools rather than gas pools?
I I don't not familiar with the pool. I mean, sorry, I'm provided those pools from our regulatory department, so
Okay, I understand. I just wasn't sure. I know you and Miss Bennett had a number of questions. I guess I was trying to confirm what your understanding was. I guess if I were to provide to you that the Wolf Camp is in fact an oil pool in this area, do you understand what I'm referring to?
yes.
Can I ask Mr. McClure to provide what the pool code is for the Wolf Camp?
Yeah, let's
Yes,
wait till
absolutely. But
let's wait till after the questioning's over, then by all means, we'll do that last before we quit.
Thank you.
yeah, I'm looking at page 130. That's just one of your breakouts of ownership. And there's reference in this table to two different entities, which is under contract for Permium to acquire. Do you know what I'm referring to, Mr. Haddock?
Yes.
Can you provide a little bit more detail in regards to the contract?
We have a signed trade agreement with them that is set to close probably in the next week.
Okay, so is this, well, I'm not to compare to the Avant. I guess, would it be accurate then to say that there's a signed agreement where these entities intend to sell their interest to Permium, but that it has not actually traded hands yet?
Correct.
Okay. Would it be accurate to, do you believe that these entities could back out of that intent and not sell its interests to Permium?
There's a signed agreement in place. I mean, no deal is ever complete until it's closed, but I mean, the probability of there's not a really mechanism for them to back out.
And earlier it sounded like, under questioning from Ms. Bennett, you had saw there was a typo in your table on page 132 in regards to the tracks attributed to Earthstone in this instance. Is that correct?
Yes,
And if I were to ask you to correct that, you understand what I'd be asking for?
yes, I could do that.
I guess backing up just a little bit, the two entities that it states is under contract for Permian Resources to acquire, that being, well, I guess they're probably both Waterloo Resources. Is that correct?
Yes, Waterloo is their collective parent company.
Okay. Was Waterloo provided notice of these cases?
Yes, I believe so.
Mr. Haddock, I don't recall if you included this in your testimony or your self-affirmed statement. Do you believe that Permian and Avant both negotiated in good faith?
Yes, I do.
Thank you, Mr. Haddock. I don't have any further questions for Mr. Haddock, Mr. Hearing Examiner, but after cross-examine, I wonder if I could ask Ms. Hardy or Ms. McLean a quick question before we get too far adrift.
Okay, and they have a question for you as well.
I do.
Huh.
Yeah. Yes.
Oh, yeah,
yes.
the pool. That's right.
Go right ahead.
Oh, did you want me
Mr.
to go
McClure.
ahead, Mr. Hearing
Yes, go ahead.
Examiner, or let's
Let's take care of
okay,
it.
Miss Hardy, do you believe, or not Miss Hardy, Miss McLean, do you believe it's accurate that notice was provided to Waterloo? I just asked you because it's part of your notice, and I don't recall as they were included.
I believe so. And they were actually a party to this proceeding. They've been entered until yesterday, I believe. They withdrew. So they've gotten notice of everything.
Oh, this is the applicant that, or the party that Miss Luck was representing, is that correct?
Correct.
Okay. Okay, thank you, Miss Hardy. Let me bring up one of the Wolfcamp cases rather than this Bone Spring. Okay, the correct pool for the Wolfcamp is going to be the Hat Mesa semicolon Wolfcamp. That pool code is 96438.
Great. Thank you.
Okay, redirect?
Yes, sir. Thank you. Mr. Haddock, as far as you know, no one is denying that the conversion right exists, correct?
Correct.
And you disclosed in the tables, I'm just going to bring it up here. Share my screen. And I think Ms. Bennett showed you this exhibit as well.
Exhibit what?
This is exhibit A6, page 2 of exhibit A6. You disclosed in the tables that you were basing the working interest calculations on the option to convert, right?
Correct.
And would you agree that because of the assignment, the contract that was put up on the screen, each party has a right to exercise the option to convert?
Yes,
So would you consider that right more than just an opportunity?
yeah, yes,
It's a property right,
it's a
correct?
property right, yes,
That's filed with the county records.
yes.
And I think Ms. Bennett walked you through the issues with the C-102s and the acreage, and you intend to correct that, correct?
Yes,
And now that you know that it is in fact an oil pool and not a gas pool, which we believed, you won't have to file any NSLs or NSPs.
no,
So there's really nothing that you would need to do administratively to fix that piece of the application, is there?
no, not that I'm aware of at this time.
And in your applications, did you include everything you believe to be an overlapping well in these spacing units?
Yes, based on the pool codes that we were provided at the time.
And has Bennett asked you about your discussions with BLM about the inability to drill in the north half of section 26? And you will, if you can find it, you will provide those communications with Mr. Rutley?
Yes,
And it would be self-development in your characterization of things.
we could self-develop all benches if that drawing existed.
But because that drilling no longer exists, it's your understanding from BLM that that's not a possibility.
Correct.
I think those are the only redirect questions I have.
That raise any?
Yes, from Mr. McClure. I have a few follow-up and also from Ms. McLean's recent questions. I'd like to look at the Avant rebuttal exhibit A1. If you don't mind stopping sharing. Thank you. Thanks.